another edition of Ask Michael Ehline. This is where I teach people the law in an unorthodox manner by using examples that we see in the news, case law briefs, but it's all about exposing the Leviathan and its instrumentalities and taking back your rights. Know the law and mean to keep it well. Come here to learn from an expert to know your right. Make sure to like and subscribe. Make sure to save, because we never know when the thought police are going to take down this channel. That's right. We never know when the thought police are going to take down this channel. So I am attorney Michael Ehline. I am an attorney licensed in California and Texas, and I'm in the process of trying to get barred into Arizona. So I'm not licensed to practice law in Arizona yet, but I have been covering the Lane Meyers saga, the never-ending saga of Lane Meyers in Arizona. But there are also some other news stories that I want to cover because I probably won't be able to go live in the same way that I normally do this weekend. I'm going to be in Texas. I'm going to be one of the hosts of the Paul Ehline Memorial Ride / the Leathernecks Peacemakers event that we're going to be having. I think it's going to be in Conroe, and there is a flyer on my community page if you guys want to come and join me for a near beer or something and hang out with the Marines. We raise money for service-related cancer victims and stuff like that, and just hang out. We've got a Navy SEAL who used to be a combat corpsman. Most of my buddies are combat veterans, so I'll be hanging out with them, and we'll just be, having a good time talking about the Marine Corps and the Brotherhood. And of course, we consider corpsmen to be Marines, but in this case, he's also a SEAL, which is kind of cool. And we'll just be hanging out in Texas. So I'll try to do some streaming from there. And of course, it's a Leathernecks Motorcycle Club. And these are the guys, as most of you know, I do personal injury law. So most of my cases come from veterans. Most veterans that I know don't want to hire you unless you served in the military. And most veterans, whether they were Marine Corps, Air Force, or Army, for whatever reason, the ones I've dealt with, they want to hire a Marine to represent them. I think they realize that we're just super gung-ho, highly disciplined. And when we look you in the eye and give you our word, we're bound by a particular sense of honor that is inherent in my beloved Corps. So there's that much. Oh, look, there's already some people joining me. What's going on, Let's OTBO? What's going on, Just Willie? So as we know, really quickly, privates. This is a public service. I think he's live right now covering what's going on with Lane Meyers. I covered a little bit of it last night, but basically Lane has been arrested once again, right in the middle of a hearing. He basically had cops waiting for him right outside the hearing while he was trying to get a Feretta motion ruled on where he could represent himself. And then immediately they wanted to throw him in the clicker. And, basically it looks to me, from my unbiased opinion, that you've got prosecutors who are all friends with each other, and one of the family members of another prosecutor feels like she's being harassed, and she's also what many of us would consider to be a public servant, has a taxpayer-funded job at a university or something like that, or at least subsidized by taxpayers. So Lane is upset because one of these people got his wife fired, allegedly, from her job working for a federal judge as a clerk. And I think she'd worked there for, 5 or 7 years. It was a long time. So he made it his personal, crusade to expose the corruption in these government-run universities. And so it segues in. So today we're going to talk a little bit about Doge. And a lot of you guys don't like Doge because CNN tells you what to think. But other people who understand that these government tax-funded agencies like USAID have basically been used as the personal piggy bank of the far left for the last, 30 or 40 years, where they're using these to fund, organizations like Antifa and BLM to basically create unrest. Right now, you've got tax-funded NGOs basically leading the way to try to tell people to attack Teslas and light them on fire, burn them down, right? The same people who said that the few people who got out of hand during January 6th are the same people who are with tax dollars telling people to lead violent protests against people just because they bought a car. So the hypocrisy in our media is so extreme. a lot of people come to my channel because they want to hear something other than just the bought and paid for, BBC, National Public Radio, far left, progressive propaganda, which is basically all our news media has been for years. And that's why so many people turn to guys like me and Twitter, X, to try to get unbiased news, or at least the real news that's not been, bought and paid for by the progressive left. So the first story that I'm going to cover is, sure enough, you guys check this out. And this is true. Go Navy. Yeah. So part of what Doge has uncovered, and this is why the Democrats are so upset, is that indeed leaked documents reveal that riots are organized and funded by leftists using non-governmental organizations. And we know for a fact that non-governmental organizations with your tax dollars were flooding the country with unaccompanied minors into this country. And many of these minors went to foster homes with known abuse, foster homes with people in those foster homes known to be child abusers. Child Protective Services, in accompaniment with these far left non-governmental organizations, has brought in at least 500,000 unaccompanied minor children into this country with your money and placed them in foster homes that are dangerous to their very survival. We know that. We know that let's say that you throw your passport or your visa on the other side of the border wall, and you're a military-aged adult male. You have no proof of who you are, no way for the government to know if you're a predator or anything. You just grab someone's kid and walk across. We're getting to the front of the line. And of course, you hear these people who call themselves libertarians say, yeah, but we need open borders. We need to let, how dare you stop these people, those poor illegal aliens. Guys, these people are being invited here with your money, okay, your tax dollars. It's not like a traditional libertarian open border, all right? In a traditional libertarian model, you don't have income taxes. You don't have taxpayers providing free hotels, free meals, SNAP benefits, free healthcare for illegal aliens. So that's the difference. So there's a total, so if you're a true libertarian, you won't support any of that either. And guess what? These people wouldn't be coming if they weren't getting all that free stuff. Give me a bunch of ones if you agree. The other issue is these people are being brought up here for the sole purpose, and this has been admitted to by the far left, for the sole purpose of redistricting all the red states blue using the United States Census. That's all this is about. Schumer and Obama, this was their plan the whole time, to use your tax dollars to flood the country with people, military-age males, bring in minor children at the same time, and then go ahead and basically destroy the Second Amendment, because you know that the Democrats don't believe in the traditional understanding of the Second Amendment. We know that. And that's why the first story that we're going to cover today is a Second Amendment case, Ninth Circuit, which is going to, these Catholic charities, I don't even call them Catholic charities, Sinful Toaster, because traditional Catholics don't support this modern day Pope. Traditional Catholics don't support people like Nancy Pelosi, right? They just don't. The new Catholics are like the new Lutherans, right? The rainbow flag ministers, right? Who just ignore everything the Bible says and say, oh, whatever feels good, that's what the Bible really teaches it. So there is no more moral standard in these people who have hijacked religion for their own leftist reasons. So give me a bunch of ones if you agree. Good seeing you, Napoleon. You're right, Sinful Toaster. I agree. So the first thing I'm going to do is just really quick, just cover this NGO story. This is unbelievable. So leaked documents reveal, and this is a leaked document, and it literally is telling these Antifa guys, don't report any income you make from us is tax income, right? Which is a violation of law, right? But do you think that one of these Democrat IRS agents would really prosecute one of these guys or go after him? I think most people think that Liz Lerner, who purposefully targeted the Tea Party guys and targeted anyone who believed in God or the Second Amendment, an Obama appointee, of course, do you really think they'd go after these guys? And that's why most people realize that the Democrats use, because most government agencies are 1,000,000% Democrat. Most of their donations go to Democrats. Their unions are all 100% Democrat. And so they're using your tax dollars to basically make sure to attack anyone who's not a Democrat. And we saw that with all the charges that were levied against Trump, whereas he actually had presidential privilege to take documents from the White House. Biden did not. He was stealing documents, secret and classified documents from the White House, putting them in his garage next to his Corvette. And then, of course, we saw the FBI say, "Oh, well, he's too old. he's too senile. We can't prosecute him for that." And now we find that all the pardons that he signed were signed with one of these electronic pens, and he wasn't even in the White House when they were signed. He was on a vacation somewhere, sleeping on the beach. So we're seeing, basically what happened here, the Wizard of Oz president. But if you look at this is a non-governmental organization funded with your tax dollars, and it's telling people, these Antifa guys, that you can engage in hand-to-hand combat, but only below the neck and above the belt, all right? Kicking's not permitted unless you're provoked. You can't reach for any law enforcement officers' weapons. You can't bring anything to the demonstration. You can only engage in the use of the props that they give you, like the George Soros nonprofits that, funded with your tax dollars give you. It talks about your general behavior. You cannot congregate with anyone other than someone in the op or the aux ops. You can't make prolonged eye contact or speak with more than two other ops, because they want to make sure you're not talking to an undercover. And when you're not in crowds, you have to keep your hands out of your pockets, keep them visible. So they're just basically telling you, you have to have a personality profile assignment that they assign to you. And this is what they teach these guys who are like lighting Teslas on fire with your tax dollars. They're teaching them all this stuff, and you're paying for it. All right. Aggressiveness, adjutorgs will update you before the mobilization. This is where they fill up a U-Haul truck with a bunch of you guys, a bunch of these Antifa types, and they drop them off at the location. A lot of people think that those Nazi guys are actually progressive liberals or FBI agents. And now we've got documents that sort of lend to that theory that could be true. Do not engage them on any level that makes you perceived as friendly. Allied law enforcement, listen to this, allied law enforcements have been instructed merely to not engage. They have not been told to assist. So that's January 6th. You've got, you've got these guys who are undercover FBI inviting people into the Capitol, right, and then arresting them later. And then the ones who are Antifa and stuff, nothing happens to them. And then the guy, the Proud Boys guy, the black Cuban, the Democrats say that the Proud Boys are like white. Anybody that they disagree with is a white racist, of course. And in this case, the Proud Boys, run by a black guy who escaped from communist Cuba, his parents, they say he's a white supremacist, of course. It's just crazy. But the same exact thing over and over and over again. This guy gets arrested and thrown in prison, even though he's like 1,000 miles away from the protest. So they use January 6th to silence people who are pointing out all the inconsistencies in the election. Why is it that they were putting up cardboard, blocking people from watching the vote counters? Why is it that when they kick people out, vote counters out, they started pulling boxes of ballots that were hidden under tables and running them 3 and 4 times through machines to double and triple count the votes? And you talk about that and they would call you a crazy person. Well, January 6th basically helped CNN and the Democrat run press create this narrative that anyone who questions the election is a crazy person. And now we know that there were government agents in the actual crowds inviting people into the state capitol. And now we know, based upon these documents, that there are allied law enforcement officials, this is their own document, all right? So they call them adjutorgs. So, and AOEC representatives will let them know what's going on. And that's why they all have the signs that look exactly the same. They all have the same protest signs. Same thing with the news media. They all report the same exact thing, same canned speech. It's all coming from tax-funded, non-governmental organizations that you paid for, okay? So I will provide this link in the sidebar for you to check it out yourself. Just give me 1 second. Yeah, Toy, I have read quite a few of the reports, and being a lawyer, I'm privy to a lot of the defense activity, and I have friends who represent a lot of the January Sixers who were illegally confined in tiny little cells and disallowed legal counsel and treated worse than the terrorists at Guantanamo Bay by these DC cops, which many people believe the DC police are basically just a bunch of hardcore Marxist Obama Democrats, and they treated these January Sixers worse than whale shit. So unbelievable what happened there. Really, really scary stuff. So yeah, absolutely sinful, Toaster. Major PSYOP players were in attendance on Jan 6. And that's why, Liz Cheney and all those guys destroyed all of the January 6 records, because they didn't allow any type of evidence into those hearings that was exculpatory, right? And they lied. They edited out stuff. They didn't allow the chief of the DC police to testify that, in fact, Trump had ordered the National Guard to show up, and Nancy Pelosi remanded those orders. All that stuff was completely concealed, and then they used this as a basis to try to impeach Trump. And in Trump's tweet that was deleted by Zuckerberg and the CIA run Twitter at the time and Facebook, they deleted his last tweet that said, "I want you to be peaceful," and then they banned him from those platforms. So, and many people are saying that's because they wanted to create this false narrative that there was no election interference. And I think most people know now that there's no way that Sleepy Joe, a man obviously suffering from dementia from day one, didn't get 81 or 82 million votes. It's ridiculous. Give me a bunch of ones if you agree that that's ridiculous. I mean, the guy was a joke. And we also know that at least 30 to 40% of Democrat voters, based upon studies and polls that were taken after the election, if they had known that the Hunter Biden laptop story was true, they would not have voted for Joe Biden. And we know that that story was covered up, that at least 60 Democrat, CIA, NSA, FBI officials, all Obama appointees, lied and said, "Oh, well, it's more likely this is Russian." They always call it Russian disinformation. Trump is a Russian agent, when in fact Hillary Clinton is the one responsible for sending our plutonium to the Russians. Remember that? She was behind that deal, helped broker that deal to send U.S. or Canadian U.S. company plutonium over to Russia. And so Saul Alinsky made it very clear that you accuse your enemy of doing what you're doing. So it was never Russian anything. It was a true story. The Hunter Biden laptop was true. Hunter Biden just dropped his lawsuit against the blind guy who was the computer repairman who turned over the computer to the FBI. And so, now we know that that was a true story as well. And then we've been told that the Wuhan story was all made up, that it's racist to say that I can't even mention the word because YouTube still wants to ban people for talking about it. But it's racist if you say this particular thing happened at a lab in Wuhan. Remember that? Oh, it's racist against Asians to say that they were doing illegal experiments and it broke out into the population. And that's all a lie. And it's racist to say that Fauci was behind laundering money into the NIH, which that lab got. And now we know that all those stories were also true, and they were also covered up by the leftist press. So everything that Alex Jones was accused of being a conspiracy theory about, everybody that accused me of being a conspiracy theorist or being anti-vax or whatever, every single theory has now been proven true, from the Hunter Biden laptop all the way down. And we know that tax-funded NGOs were behind this. So let's go ahead now, and it's just unbelievable to me. So it is mob rule, Sinful Toaster. That's right. That's right. Z Lanson makes it very clear. It's not racist. It uncovered the fact that we funded it. All right. So many of you guys, that's right. The Clinton Foundation, total fraud, Westman 78. And we know that money was used from the Haiti fundraisings to help the daughter of the Clintons buy a home, allegedly, as well as pay for her wedding, like $10 million or something dollars. And of course, because the left controls our news media, CNN, PMSNBC, I would say 99% of the press, the entire national public radio, all of them are far left Democrats. There's not a single conservative at the tax-funded what do they call it, national public radio, which you also pay for with your tax dollars. So you're not getting real news, you're getting Democrat propaganda. And look, I'm a libertarian, so I don't really have any skin in the game. I think both parties are totally corrupt. But I also know that the left runs the news and they control most of social media. At least they did until Elon Musk came out and started allowing people to actually report the truth. And I think that's why so many people support me, as well as Joe Rogan and non-traditional sources of news, because everything that I say to you ultimately turns out to be true after, all these bots and people try to make me out like I'm a crazy person. Look, I'm just a lawyer who's capable of doing research and wasn't brainwashed by the far left run public school system. And that's why I teach people that you should homeschool your children. You should form parallel systems with like-minded people, learn about John Locke, study natural law, understand that our rights come from a creator, not from the state, and then everything will start to fall into place, and you too can become a critical thinker. Give me a bunch of ones if you appreciate that philosophy. So, and Zealand, and you have been right so many times. And you're right, Zealands, and I agree. Trump used a lot of bad advisors, and he probably still does, because these are the billionaire types, the Jekyll Island types that want to keep our fiat currency system in place. And did you guys just hear recently the IMF is saying that you shouldn't get into Bitcoin because it's too volatile? Like the IMF isn't too volatile, or fiat currency is not too volatile, like currency that has no value other than no intrinsic value other than its perceived value and that it's backed by our government. A bunch of corrupt politicians, like that's not volatile. Are you kidding me? All right. So yeah, you're right. Brick and mortar schools are prehistoric. Well, our original public schools were imported here by the Rockefellers because they wanted a nation of workers, not of thinkers. And that has proven true. When and that comes from the Prussian education system, starts back from the Napoleonic Wars, where the King of Prussia was very upset that his troops mutinied and ran. And so he wanted to form a system from childhood where children would be loyal to the state. And that's all public schools have done. And now you see they got the rainbow flags, the BLM flags, and the Ukrainian flags all over the public schools. You drive into any public school parking lot and you look at the teachers' cars, their bumper stickers. It's all pro-Obama, I'm a leftist, Che Guevara bumper stickers. They're all hardcore Marxists. Why would you send your kids to a public school if you don't support that? And like Malcolm X said, why would you let your enemy raise your children? And essentially, that's what you're doing when you send your kids to a public school. Give me a bunch of ones if you agree. Now, well, how could they be armed? Lab says that we should mandate that teachers be armed, but why would a far left Marxist want to be armed? They believe that only the government should have arms, right? Only the people that they put into power should have arms. And why wouldn't they believe that when Mao Zedong said all power emanates from the barrel of a gun? Well, they want to have absolute power. So why would they want a free person, a free thinker, to be able to defend themselves? Of course, they would not. So, all right. So let's get into, well, hold on. Somebody says, Zealandson says, bad schools happen when lefties run them, not everywhere. Well, find me one government employee besides like the Marines or military, right? Excluding the Air Force, because I would say they're 99% leftist Democrats, right? But find me one government agency other than the military that isn't like 70 to 90% Democrat. Just find me one, even the prosecutor's office. Come on, guys, give me a break. Most people who are leftist want to be working for the state because it's cradle to grave, guaranteed, pensions, tax funded, everything. They don't really have to work, right? Not like you and I have to if we're entrepreneurs and we have to support a family. We're their enemy. Like you go to the IRS, they look at people like us. Oh, that's a piggy bank for us, right? Oh, you have a job and you don't work for the state. Clearly, you're probably a criminal, right? So we have to audit you, right? That's kind of like the stories that I hear. So anyways, ever since the creation of the public education system under, well, the Department of Education under Jimmy Carter, our country went from, I believe, either number one or one of the top 1% of education down to the very bottom. I mean, our education system is trash. Less than 25% of the federal funds that go to the Department of Education actually go to the kids. It goes to this bloated bureaucracy, and that's what they want. Because if they can give you, like this DEI hire $500,000, well, they know a portion of that money goes to the union, right? And then the union donates all of their funds to Democrat candidates. And it's just basically created this system of free tax-funded money that flows back to the Democrat Party. In fact, most people that I've spoken to who are parents believe that if not but for all the tax-funded money and the Democrat control of the press, most people would not vote Democrat, because most people don't support drag queens hanging around with kindergartners, right? But if it's forced into your mind that that's normal, and you see it at every Target, you see it at every restaurant, you see billboards everywhere that it's normal, you're taught that you're an outcast if you don't go along with the program. And that does start in high school with peer pressure. And then it just continued on with tax-funded money going to brainwash people into thinking that there's a consensus that that's normal. But most people in this world don't believe that it's normal. And so as these agencies get abolished, the left is very upset. So they're attacking guys like Musk, trying to destroy his car company. Now, I remember when people got upset about Bud Light, right? I didn't see parents and family members burning Budweiser trucks. That's the difference between the so-called conservatives and the leftists. When conservatives get upset, they just stop buying and they turn their backs. When leftists get upset, they start vandalizing, burning down buildings, attacking you, swatting your house. So there's a big difference between the two guys. And being a libertarian, I'm able to look at both sides and I can see the difference very clearly because I don't have any skin in the game on either side. But let's see here. Sinful Toaster says they tax your property before it can realize your gain, and you can't tax unrealized gain. Well, they're just doing anything they can to make it hard for regular people to survive because they want everyone to be a ward of the state and dependent upon the state. Give me a bunch of ones if you agree. Now, SW Observer, good seeing you. Totally off topic, 5 p.m. Friday here in Sweden. What time do you have? Right now it is 8:53 a.m. in Pacific time, guys. So what I'm going to do, guys, I am working today, and I just wanted to do the intro. I got to jump on a flight. For all you CIA guys, I'm flying tonight. Please don't take me out, because the more effective I get, the more you guys will use your little secret weapons to silence people like me. So, guys, if something happens to me, I didn't SUICID myself, okay? And so let me see here. Let's get into my first show of the day. Hold on. So this has to do with Duncan versus Bonta. All right. So what I'm going to do is I'm going to play the video where Michelle, he's one of the best two-way lawyers in California. As you guys know, I am a Second Amendment rights lawyer. I have Alan Beck, who's with my firm. He's one of the preeminent Second Amendment rights attorneys in the country. And we do a lot of Second Amendment rights cases. And I don't consider it to be a Second Amendment right. I just say that word tongue in cheek. The right of self-defense is an inherent right that was granted to us by our Creator under natural law. And there's no supreme law that can be written down or unwritten that would ever deprive you of the right of self-defense. And that is what our founding fathers also believed. And that comes from ancient common law principles. But nonetheless, we, because of Dick Heller, my friend, and yes, Dick Heller is a buddy of mine, and that's Heller versus DC and DC v. Heller. We had a whole new line of cases because now it was absolutely, these leftist judges were kind of screwed. These Democrat judges were screwed because now they were forced to recognize that the right to keep and bear arms is an inherent right of we the people, not just the so-called military, which that's what the leftist judges try to do. Oh, only the military. It's like, no, dude, the whole point of having an armed militia, regulars and irregulars, is so we could fight against the state's military if we had to, if they tried to violate our rights. That's what it was all about. But that's, the leftist judges don't like that because they only want the government to be able to have guns because it's easier to crush people who oppose you if they can't defend themselves. Give me a bunch of ones if you agree. So basically what happened is a whole new line of cases came out about how, well, now we have to show, if there's a historical right, yada, yada, yada. So California has just been hell-bent, along with the leftist Ninth Circuit, on being able to decide how many rounds you can have in your weapon. They say, well, if you have 10 rounds or more, that's really dangerous and unusual. And therefore, we need to ban these magazines to make sure that you're not able to have as many rounds. In other words, you'll be less effective in a firefight. And their theory is against the government, which was the whole point of the Second Amendment right, to be able to defend against all enemies, foreign and domestic. So they classify the magazine as an accessory to try to get around the fact that a magazine is actually a material component of the firearm. It is, in fact, the weapon itself, because the manufacturer specs, and they try to call a standard capacity magazine high capacity, right? So they always use semantics, right, to try and brainwash the soccer moms, right, the voting class, to think that, oh, it's really dangerous. It's a high capacity. No, it's the manufacturer spec magazine. 30 round mag is what most AR-15s come with, manufacturer spec, right? Your typical Glock 21 is going to be, I think, a 13 round mag. Your typical Glock 19, I think it's either 15 or 17, if I'm not mistaken. But yeah, those are called standard capacity magazines by the manufacturer. But by the time you get it into a leftist judge's court, or a leftist politician in California who knows nothing about firearms other than, oh my God, they're so dangerous, that they're going to call it a high capacity because it's more scary. But these guys know nothing about the firearm. They know nothing about components of a firearm, but yet somehow they're an expert to be able to say that the magazine is really not an inherent component of the firearm. So what we're going to do is we're going to cover that right now. And this is going to be, I'll drop this guy's video. Hopefully he's not going to be too upset that I'm covering him. It's CRPA TV. And my buddy Alan knows these guys, Alan Beck. And we're going to cover it real quick, real proper like. And then I'm going to show you a video of one of the dissenting judges on the Ninth Circuit. And he just breaks it down better than I would, like cutting a hot knife through butter. But you're going to love this video. And I got to get some work done, but I'm going to be cutting back and forth to just tell you what my thoughts are on this. All right.
Let's talk about it. Hey everybody, welcome back to the channel today. It has been long awaited once again, but we do have a decision in the Duncan v. Bonta case. That is our challenge against the constitutionality of standard capacity magazines here in the state of California. Looks like history's repeating itself once again, but to walk us through it, we have brought back on volunteer president of CRPA. That is Chuck Michelle. Chuck, thanks for being with us today.
Oh, it's a pleasure, fellas. Big news today.
Yes, absolutely. So, guys, as always, be sure to like, share, and subscribe to these videos. We're trying to get this information out as quickly and effectively as possible. This is going to be a big one, potentially causing a lot of movement and litigation. So please like, share, and subscribe. We want to get this as far and wide as possible. So, Chuck, now is normally when I would be asking you if you could give us a rundown on the history of Duncan. I feel like some of it is incorporated here. I wanted to read the summary from the opinion itself. By the way, guys, link in the description below, 147 pages of majority opinion, dissenting opinion, and some dissenting and concurring opinions as well. A lot of legal talk about magazine and the Bruin decision. After the video, please read the whole thing. There's a lot of good and a lot of bad information in there. We're going to talk about some of that today. But from the summary, here we go. Buckle up, guys. This one is a bit of a long one. The en banc court held that the California law banning the possession of large capacity magazine comports with the Second Amendment, reverses the district court's contrary conclusion. And remanded with the instruction to enter judgment in favor of the Attorney General of the United States or of the state of California. Employing the methodology announced in New York State Rifle and Pistol Association v. Bruin, the en banc court concluded that California's law comported with the Second Amendment for two independent reasons. First, the text of the Second Amendment does not encompass the right to possess large capacity magazines because large capacity magazines are neither arms nor protected accessories. Second, even assuming that the text of the Second Amendment encompasses the possession of optional accessories like large capacity magazines, California's ban on large capacity magazines falls within the nation's tradition of protecting innocent persons by prohibiting especially dangerous uses of weapons and by regulating components necessary to the firing of a firearm. Accordingly, the en banc court remanded this case to the district.
Sorry about that, guys. I see that I was on. Sorry about that. Okay, so really quickly, let me just circle back. So there's a misunderstanding of the term dangerous and unusual. So the leftist courts have long tried to reinterpret what the common law meant, or just simply ignore it and come up with a new definition. What dangerous and unusual means, and that's what they're trying to use. Well, it's dangerous and unusual to have a 20-round magazine. It's large capacity. It's dangerous and unusual. Dangerous and unusual simply meant time, place, and manner of the carriage of a weapon itself. So it might be considered dangerous and unusual at common law to tow a howitzer cannon, right, through a shopping mall. You understand? That might be considered an unreasonable time, place, and manner restriction. So the en banc Ninth Circuit Court wrongly decided this case by simply not understanding the historic underpinnings of what dangerous and unusual actually means. It has nothing to do with how many rounds are in a magazine or the way a weapon looks, because it looks like an AR-15, so it's dangerous and unusual. It simply meant how you carried the weapon, when you carried it, and then the time you carried it. Like, right. So let's say you're at a political rally, right? It might be deemed dangerous and unusual to have a bunch of people in the audience carrying sniper rifles, right? An unreasonable time, place, and manner restriction, right? That kind of stuff. It had nothing to do with how many rounds the magazine had or anything like that. This is all just a complete ignorance of understanding what dangerous and unusual means. So I just wanted you guys to understand that. But let's get into it. I'm going to put myself on mute.
District Court with the instruction to enter judgment in favor of the California Attorney General. Dissenting Judge R. Nelson agreed with Judge Bumate's dissent that the majority opinion to reverse the district court on the merits flouted Bruin. The majority's decision also spurned the statutory procedure for an en banc proceeding because, as explained in his dissent from the order filed concurrently with the opinion, this en banc court lacked statutory jurisdiction to decide this new appeal. Dissenting Judge Bumate, joined by Judges Ikuda, Nelson, and VanDyke, would hold that nothing in the text or the country's historical understanding of the Second Amendment warrants California's magazine ban. Applying the Bruin framework, California's magazine ban is presumptively unconstitutional because the plain text of the Second Amendment protects the possession of magazines capable of feeding more than 10 rounds. California failed to overcome the presumption of unconstitutionality, where California failed to identify a historical analog that was relevantly similar to a ban on these magazines. Accordingly, he would hold that California's magazine ban is unconstitutional. Woo! Okay, so break that down for us here a little bit, Chuck. You have some of the majority opinion there, some of the dissenting opinion, and a little bit of what happened during the oral arguments in the Ninth Circuit en banc panel, with Judge VanDyke just going off about whether or not this panel should take the case at all. After the first glance, and I know that there's going to be a whole lot more interpretation of this 147 pages to come, but at first glance, where are we with this opinion?
We are going to the Supreme Court is the answer to that in a nutshell. And it's an opportunity for the Supreme Court to set the record straight, to clarify Bruin's methodology, to stop the shenanigans that lower courts, in particular the Ninth Circuit, have been playing with how to interpret Bruin and apply the Bruin methodology correctly. And they could, I mean, there's several progressively inclined courts that have bent over intellectually backwards to try and twist the Bruin and the Heller rulings so that they can uphold all manner of gun control laws. And the Supreme Court now has the opportunity to emphatically set the record straight and correct the misinterpretations that these lower courts have been making of the Bruin decision. Now, that is the short answer. We're going to SCOTUS. We've been there before. The Supreme Court had been asked to consider Duncan. Remember, this case was filed in 2017. And this oral argument that we just got a ruling on today was made a year ago. So they sat on this for a year. I fully expect that the Supreme Court, and this case also is in a good procedural posture because this is from a judgment from Judge Benitez down in San Diego. Not a preliminary injunction ruling, which is one of the reasons why the Supreme Court has not been taking what otherwise would be good vehicles for a Second Amendment review, because they were up on preliminary injunction rulings rather than a final judgment. This is a final judgment. This is the right procedural posture. The record was developed, and it's all the evidence is in. And so what the Ninth Circuit has done is narrow what is considered an arm. Remember, the Bruin test says you first figure out whether or not the language of the Second Amendment applies, the right to keep and bear arms. What is an arm is something that's being debated right now about suppressors, about magazines, about other gun parts. In Illinois, they're arguing about whether they can ban parts or repairs. So the threshold question is a magazine, a arm, is what the Ninth Circuit spent most of its time doing. Then the second question is, assuming that the Second Amendment language covers the item, the gun or firearm part or firearm accessory or whatever, or ammunition or whatever it may be that is being banned or regulated, then is there some historical analog law, some law that was passed for the same reason and was put into effect in basically the same way? So that's the how and why test from Bruin. Is there a historical law that that lines up with and indicates that the founding fathers would have tolerated this modern law back in 1791? And that's really secondary in the Duncan decision about the historical analogs, but they got that wrong too. They grasp the flimsiest of analogs, and like they're basically saying now that, well, they've regulated dangerous things before, so this is a dangerous thing, so they can ban magazines because there's historical precedent. But before they even really got to that, the serious first threshold question is whether or not a magazine is an arm. And they got into a big debate about what's an accessory and what isn't. And Judge VanDyke's video illustrates this point beautifully, because so can they ban grips? Can they ban different types of sights? Can they ban different types of triggers? Where all those things could be considered accessories and not a fundamental core part of an arm. And again, folks should watch Judge VanDyke's video. I can't do better than that to explain how dumb the state's arguments are here about.
And I'm going to play that video for you. It's going to blow your mind. I know a lot of you guys hate lawyers and you hate judges, but I got to tell you, there are a few of us out there who support the Constitution, support natural law, support the concept that the government is the servant and not the master. And you're going to see a brilliant demonstration by Judge VanDyke of exactly that, of a few of us that are still left who haven't been brainwashed by the administrative state. Let's go.
Why magazines are not protected by the Second Amendment's plain language.
Yeah, that is a fair point. Jacob, if you could put the link for Judge VanDyke's video in the description below, maybe a little bit more homework on top of the 147 pages to read, but it really kind of illustrates the disparity of knowledge that you can see between the judges. Judge VanDyke is extremely knowledgeable about firearms, which is why he's able to put up those arguments where, as you can see by the majority opinion, there is certainly a lack of knowledge that those arguments have to come from here. You did kind of touch on the testing that goes with the Bruin test. In Judge Bumate's dissenting opinion, it was kind of touched on that they strayed from that altogether. I know something that we've been talking about since Bruin dropped in 2022 is that the Ninth Circuit and some of these federal district court judges were going to be working to sidestep Bruin as often as they can. I wanted to read this, Jacob, if you could pull it up. In Judge Bumate's dissent, it's literally titled "The Return of Interest Balancing." It reads like this. The majority upholds California's magazine ban despite Heller, McDonald, Bruin, and Rahimi. In doing so, the majority rejects the Supreme Court's Second Amendment framework and reads the amendment as it wants. First, the majority haphazardly establishes two Bruin tests, the so-called more nuanced and unnuanced approaches. If that sounds confusing, it is. In fact, it's so confusing, the majority largely abandons its own creation mid-opinion. Second, rather than examine historical analogs for the similarity with California's regulation, the majority simply cloaks interest balancing under the guise of tradition. So in the Ninth Circuit, we've returned to the old days of judicial policy making that the court has gone out of its way to end. Now, I guess kind of a two-part question here. We've been talking about courts wanting to do this. This becomes a little bit more flagrant. I guess really it's only one question. Does something like this make the Duncan case really ripe for the Supreme Court to want to take?
Yes, because this is lower courts, and in particular the Ninth Circuit, which is the most frequently overturned circuit court, even though now it's almost 50-50 with the previous Trump administration's Ninth Circuit judicial appointments. But the Ninth Circuit has notoriously been overturned. So that's factor one. But factor two is that they're thumbing their nose at the Supreme Court. And the Supreme Court, it's not the first case that did this. So I think the Supreme Court really wants to get in there and basically straighten some of these lower courts out. But again, some of those have been going up on preliminary injunctions rather than on judgments, which this is. So it's got this Duncan decision has several things going in its favor. Also, it's been up there before. They vacated the Ninth Circuit's previous en banc ruling from several years ago because it was wrong, and Bruin came down. And so in light of Bruin, they said, reconsider everything. The Ninth Circuit took it back. Then the Ninth Circuit sent it back down to Judge Benitez. We've tried this case in front of Judge Benitez twice. And there's an awful lot of work involved in that. And then it went back up. So it went from the district court win in years ago to a Ninth Circuit 3-judge panel win, then to the en banc loss, 7-4, which is the same numbers we got this time around. Then to the Supreme Court. The Supreme Court vacated the loss, sent it back down to en banc. En banc sent it back down to Judge Benitez. Judge Benitez tried the case again. It went back up. The en banc panel grabbed it, and that's where there's a sideshow, a separate opinion issued by the Ninth Circuit that said it's proper for the en banc panel to take it back without going through a 3-judge panel first. But that's basically a red herring issue, legal procedural issue. And so now we've gotten this ruling from the en banc panel, which we will ask the Supreme Court to look at again. But with that much history, the Supreme Court is going to recognize you can't get a more thorough record than what there is, in this case. Now, there are other cases, though, that the Supreme Court's been asked to take. Snopes is the semi-auto ban case that the Supreme Court has recalendared several times for consideration. There's an Antonok, which is sensitive places. But one thing I do want to make people aware of, the beauty of having a judge who knows a little bit or a lot about firearms. This happened in Illinois too. Judge VanDyke is the most recent example because of the video that he did. It shows he knows how to shoot. He knows how a gun works. Many judges don't. They wouldn't know the business end of a gun from the other end. But for example, in Illinois, we had a district court judge who really knew firearms. The judge Benitez in San Diego knew something. If they know something about guns, then they can see through the baloney that the state is trying to sell them. But the big thing is, if you can ban a gun because the government can ban a gun because they decided it's dangerous. Every gun is dangerous. Every firearm is dangerous if it's in the wrong hands. The things that make a firearm more accurate, and they would say that makes it more dangerous, or have more rounds, or have a red dot sight, or have better grips, or have a modified trigger. All of those things make a gun more effective as a target shooting or self-defense firearm. But if misused, they make the gun more dangerous because if it's in the hands of a criminal. Now, criminals don't generally go out and shop for a gun that's been modified. They get whatever the first gun on the black market is, or whichever one they can steal. That's their weapon of choice. But law-abiding citizens who want to have an effective self-defense weapon or a self-defense firearm or a target shooting firearm, or for that matter, hunting or whatever else, they will individualize the gun. That's one of the problems with the whole roster in California, is that people have individualized needs for individualized custom firearms customized for their needs. And the state doesn't want to allow any of that. They want to basically dumb it down. It's going to come down to, Barney Fife on the Andy Griffith show. He was allowed to have one bullet, and he kept it in his pocket, and that's all you can have. So that's the state would be fine with imposing that kind of a restriction.
Yeah, and the age-old argument is that the criminal is by definition not going to pay attention to the laws. They're going to break the laws.
Well, yeah, that's the threshold flaw in all of this, which is that you can buy. There's plenty of 10+ round magazines out there on the black market or otherwise that if a criminal really wants to get that, they can.
Well, let's talk about movement here for a second. So this case is going to SCOTUS. Is this also kind of the spark that lights the fire to heating up litigation for California altogether? We had some of our big cases. We've got the May case. We've got the Rhodey case, where we're kind of assuming that those panels are waiting on Duncan to move forward. We've got the Boland case, which the panel literally came out and said, we're waiting for Duncan to move forward on this. Is this kind of the spark that sees those other lawsuits start to move forward in the Ninth Circuit?
Yes, and while you mention those cases, let me give a hat tip to the National Shooting Sports Foundation for helping to support the Boland case, and the NRA for helping to support the Duncan case. Both of those organizations deserve credit for partnering with CRPA to help keep those cases moving along. But now all those cases, they don't deal with whether or not a gun on or off the roster is an arm or a sensitive place. That has nothing to do with what arm you can or cannot take into the sensitive place. It's not the threshold Second Amendment language of the Second Amendment question. It's the secondary question. And ammunition has already been found to be an indispensable component, not a mere accessory, to the extent that accessories can be banned, which I don't think they can, because it's like banning parts. So all of those cases, I think, are going to be opened up for more briefing or for an opinion, depending on what the status, how far along those cases are. And so, yes, we will now be in full-blown litigation mode. So please help support CRPA to keep all those cases, get all those cases back in motion and try and win those. And also we have our gun show case in the Supreme Court right now. Duncan is headed to the Supreme Court. Now's the time to help support CRPA to keep all those cases moving along.
Certainly, and we are going to be here to follow along on all of those. I suspect that we will have you back soon because there will be a lot of analyzing of these majority and dissenting opinions. Probably want to do a video also when we actually file for this to go.
Sorry about that. Just so you know, I do support the California Rifle and Pistol Association, and I recommend that you do too, even if you're in another state, because the Ninth Circuit is going to be what destroys what's left of our Second Amendment. And it's based, basically it's California. So you've got a bunch of leftist, Marxist, Obama judges, we're coming for your children types, right? The kind you would find in that sphere of influence. And then you have and this is allegedly, obviously, because I couldn't say that because I'm a lawyer and I don't want to disparage the court, but many say that the Ninth Circuit is filled with far left activist judges. And because of that, they consistently rule against the rights of we the people when it comes to parental rights, when it comes to the right to defend your family, when it comes to the right to not inject your body with foreign substances, experimental substances. They consistently side with what we would consider, us libertarians would consider, the Marxist government overreach part of society, where the state gets to decide what's right and you have no say. And so because of that, the California Rifle and Pistol Association is at the forefront of defending those rights, along with a few other independent attorneys like Alan Beck. But that's the only reason why we've gotten this far, is because of Michelle, the attorney that they've been interviewing. So I highly recommend that you support the CRPA. Right. So here's what a lefty told me: a judge knows more about firearms, is biased and needs to rescue himself. That knows more. Yeah. I've never met a liberal, a so-called liberal, or even a Democrat who really knows anything about firearms, unless maybe they served in the Marine Corps. But even then, that's just basic stuff. Like, if you really want to know about firearms, you have to go to the range. You have to hang out with guys like Taryn Butler from Taryn Tactical, the guy who builds the firearms for the John Wick movies. He showed my son how to shoot at one of our last fundraisers for the Veterans Against Cancer stuff. And that's where you really learn about, essential components and all this other stuff. But basically, you've got the left trying to find a way to make the Second Amendment and our historical right to keep and bear arms say something that it never said. That's all it is. And they know nothing about guns. And so just keep watching this. This is going to blow your mind. I mean, this is a great video. Wait until you watch the judge. I'm going to show you the video. This judge made this video, the dissenting judge. It's going to blow your mind. It's going to instill some confidence in you in what's left of our judiciary that actually supports, many say actually supports, the Bill of Rights and the Constitution.
SCOTUS. Any final thoughts on this, Chuck, after first glance moving forward? What could the timeline look like for SCOTUS, and your opinion on the opinion?
Well, we'll be moving right away for the Supreme Court to take the case, because we want to get this up in front of them as soon as possible, because they go out of session in June. So we're going to try and get it up there so they might actually consider whether to take it. They won't hear it this session. So this case will not be heard. Oral argument, if they accept it, won't be heard until the next Supreme Court session, which starts on the first Monday in October. But if we can get something up there fast enough, we might be able to get it into conference and have them decide whether or not to take it, and then hear it next year. So that's where we got to run. We got to really, get to do everything we can to get it up there. But the opinion, look, it's not a particular surprise that this en banc panel came down the way it did. It's kind of the way they came down last time. And given the inclinations of some of these justices, and frankly their desire to not have a strong Second Amendment, in part because they don't understand firearms, it's wrongly decided, and it's really, it's mind twisting. It's reasoning. It's false reasoning. That they've kind of put their thumb on the scale to try and make it come down this way, because they really don't want a strong Second Amendment. And we have to, our job and the other groups that are all fighting in various states to protect and enhance and support and defend and expand the Second Amendment's protections, we're all in the same boat. But really, we're waiting for a Supreme Court case that will basically put the lower courts in their proper place, tell them what they're doing wrong, tell them how to do it right, and then move forward on all these other cases that aren't there yet.
Well, we'll certainly be following along and hoping that that is the case. It kind of feels like the Supreme Court is a light at the end of the tunnel, so long as we can get the cases there. Chuck, I know that you're already a busy guy.
Final thought. This is a historic time for Second Amendment jurisprudence. This is stuff that's going to be studied a century from now. This is part of history. Please help support our efforts. You will be a part of history. We're trying to preserve freedom. We're trying to preserve the Second Amendment. We're trying to preserve the American way of life for ourselves and for our children. So to the extent that you can help us on that mission, would all be grateful.
Absolutely. And I was going to say, I know that you're already a busy guy. These are the frantic times. So thank you for taking the time to come on with us today and walk us through this.
Yeah, thanks for having me.
Great video. Give me a bunch of ones for Chuck Michel, as well as for the CRPA TV. I'm going to drop the link one more time so y'all can have it. Here we go. Doggone it. All right. So let's get into the next video. This is going to blow your minds, guys. This judge is right on the money. I've never met or seen a judge who knows as much about firearms as this judge. And it's interesting that the more a judge knows about firearms, the less likely he is to vote like a Democrat when it comes to trying to regulate or ban firearms using the traditional historical understanding of firearms and firearms laws. It's the activist leftists, the Obama types, who seem to just steamroll everything, and they'll call a magazine a clip. They'll say it can fire 1 million bullet rounds. Like they know nothing about the firearms, but yet somehow they're in a position to decide firearms related cases. Give me a bunch of ones if you think that in order for a judge to rule on a firearms case, that they should at least understand the basics of about what a firearm is. They should be forced to go to a gun range and shoot one, learn how to clean one, learn how to disassemble one, learn the difference between a takedown pin, a firing pin, a buffer, a grip, right? A carrying handle as opposed to a freaking, Picatinny rail. Like they should have a basic understanding of what a firearm is before they can make any kind of ruling on it. I think it's absurd. And once you watch this video, you'll understand why. So let's get into this next video.
VanDyke, and welcome to my chambers. I'm making this video as part of my opinion in the Duncan v. Bonta case. In this case, the state of California made the argument, which the majority has now accepted, that a magazine holding more than 10 rounds is just an accessory, not an arm protected by the Second Amendment's right of the people to keep and bear arms. I think anyone with a basic familiarity with firearms could show you that this attempted distinction is simply inconsistent with reality. I alluded to this during oral argument when I asked California's counsel about the balance of the tests that are proposed for what qualifies as an arm protected by the Second Amendment. Let's go to that exchange now.
Magazine can I ask you a question about that? Because
yes, Aaron.
So the way you're treating magazines, it seems like you could use the same sort of rationale as between a non-semi-automatic firearm, say a lever action or a bolt action or a revolver type action, and a semi-automatic firearm. So I'm trying to figure out if you're saying, well, what we do is we say, have people ever banned particularly dangerous rounds? And now we're saying large capacity magazines are particularly dangerous. Why couldn't that same reasoning be used to ban semi-automatic firearms altogether? To say, because I mean, think about it, like during the Revolutionary War, if the United States had semi-automatic firearms that only held 5 to 10 rounds, it'd have been about 10 minutes and it would have been over, right? As against muskets. So clearly, the semi-automatic mechanism is way more particularly dangerous than the difference, the delta between a 10-round magazine and a 15-round magazine. So why does your reasoning not mean that if this reasoning works, why does your reasoning not mean that a state could just ban the semi-automatic firearms altogether?
So if we're just start talking, Your Honor, about this initial sort of textual question, I think if you're dealing with a semi-automatic, that would fit the definition of an arm.
No, but that semi-automatic could be a revolver. Like it could be, I mean, just like this, that high capacity magazine could be a lower capacity magazine.
Right, Your Honor. So I think that would fit the definition of arm, and then you'd move on to the other aspects of the Bruin analysis. At stage 1, is a particular weapon that's being addressed by the law in the tradition of dangerous and unusual? Is it in common use for self-defense? And we think Heller is clear that has to consider the character as well.
I'm not
as
understanding
the
your, I think I'm missing your response to it seems to me that just as you could say, are you saying that yes, so it would be an arm under, you're not conceding that it would be an arm under stage 1. So why are you saying it wouldn't be an arm, but the semi-automatic versus revolver, say, distinction is something that we're stuck with? I mean, you would agree that you can't ban the automatic mechanism.
Well, an automatic mechanism, I think that you can ban. I think the Supreme Court has recognized.
No, the automatic mechanism is a term that semi-autos and full autos use an automatic mechanism.
Sure, Your Honor. I'm sorry for the confusion. No, I don't think that we could ban all.
Yeah, so there is no confusion. This attorney doesn't know what the hell he's talking about. He's confusing the automatic loading mechanism of a firearm, okay? So let's say you have a semi-automatic pistol and you rack the slide and then you let it go because a spring then grabs the round, the cartridge, and loads it into the feeding chamber, right? Okay, now when you cook off your first round, boom, the slide racks back automatically. That's called an automatic loading mechanism. And this attorney has no clue what the F he's talking about. And he's arguing on behalf of the government. He thinks that an automatic loading mechanism is a fully automatic firearm. Right? And so he doesn't know what he's talking about. He's totally clueless. And the majority of judges went for him. And he doesn't know anything, knows nothing about firearms at all. He's a joke when it comes to his understanding of firearms. And they just, oh, sorry, it was just a misunderstanding. This guy doesn't know what he's talking about. Give me a bunch of ones if you agree. Completely ridiculous. I don't understand how anybody could be allowed to even argue a brief with his complete lack of knowledge about firearms. What a joke. And to have him have his side be selected as the proper argument when everything's based on a house of sand. He didn't build his house upon the rocks of knowledge. It's based upon emotional arguments, as we'll find out as we continue to listen to this hearing. Unbelievable.
All semi-automatic weapons, I think Heller makes that clear. The point I was just making is with respect to accessories, I think we have a difference of opinion where my friends suggest any accessory that is somehow helpful to armed self-defense.
So that's important because your argument turns on whether you can characterize accessory. So you would say that the revolver versus semi-automatic is not an accessory, but that a magazine is this accessory. So what would you think about like a red dot sight, electro-optics, which many firearms are going to electronic optics nowadays. They're obviously an accessory because you could have iron sights. Could you ban those?
Well, so Your Honor, I'm not intimately familiar with that. And I do want to answer this question and make sure that I save time for rebuttal. I think that the question at the outset would be, is that, if it's an accessory, is it within the Teixeira principle that it's necessary to the realization of the right to self-defense? And you'd have to build a record and analyze it in that case.
So, counsel, you're saying.
Now, from this exchange, it became clear to me that many, including both California's counsel and my colleagues in the majority in this case, lack the basic familiarity with firearms to understand the inherent shortcomings and obvious inadmissibility of the test that California was proposing, and which the majority in this case has now adopted. I originally planned to explain all of this in writing, in my opinion, and why the argument doesn't make sense. But it occurred to me that in this instance, showing is much more effective than telling. As the old saying goes, a picture is sometimes worth 1,000 words. And here I hope you will agree that a video is at least worth that much. And I suppose at this point in the video is as good a time as any to apologize for any shortcomings of the video. This is the first video like this that I've ever made. And in our digital age, I fear that people have become accustomed to a production quality that I'm sure that I fall far short of. But I hope and expect that regardless of any such flaws, this video will still powerfully serve the purpose for which I've made it. I also want to emphasize that for safety purposes, I have rendered inoperable all the guns and gun parts that I use to demonstrate today. And finally, As an appellate body, it's obviously not our role to make factual determinations, so I share this not to supplement the factual record that we're using to decide this case. Instead, I share this because a rudimentary understanding of how guns are made, sold, used, and commonly modified makes obvious why California's proposed test and the one my colleagues are adopting today simply does not work. I'm sure I could explain all of this in writing without being accused of improper fact-finding, but it's obviously much more effective to simply show you. So let's do that now. Welcome back. To demonstrate, I'm going to start with this SIG P320 that's basically in its stock configuration. That is, this gun is basically in the same configuration it would come to you from the manufacturer and be sold to you at a retailer. This is one of the most popular handguns currently on the market in the United States. And so I'm going to use this to point out some of the essential parts of a handgun. These same parts would exist on pretty much every handgun, at least of this semi-automatic type. So let me start by pointing out a few of them. This one comes with a standard 21 round magazine. Comes from factory just like that. You can buy a similar version that comes with a 17 round magazine that fits flush. And so it comes with 21 or 17 round magazine. It has a standard full size grip. It has a factory trigger, which has a pull weight of about 7 pounds or so. Has front and rear iron sights that are used to aim the firearm. It has this little takedown lever, which is small, and you may have trouble seeing it, but we're going to talk about that some later. And that's what you use to remove the slide and disassemble the firearm. And the entire gun is designed around the automatic cycling mechanism. That is, when you pull the trigger and fire a round, right when that happens, it automatically will rack the slide back, eject the round, the spent cartridge out of the gun. It will grab a new round out of the magazine, put that round into the chamber, into the barrel, and it'll be ready to fire another round the next time you pull the trigger. So this is a semi-automatic firearm. Now, I want to use this handgun to illustrate first California and the majority's argument as applied to this obviously typical and very common handgun. And then I want to show you that the same argument would apply to other parts of the firearm and to this firearm as a whole. Now, as a reminder, California's argument, which the majority's adopted here, is that a magazine that holds more than 10 rounds is not an arm protected by the Second Amendment. So this 21 round magazine that comes from the factory or a 17 round magazine is not an arm protected by the Second Amendment. Now, California acknowledges that a magazine is necessary to make the firearm function, but they argue that because you can replace the standard magazine with one that holds fewer rounds, 10 rounds or less, then these higher capacity magazines are not an arm and thus wholly unprotected by the Second Amendment. Now, the problem with California's argument is that, as I pointed out in oral argument, the exact same argument would apply to essentially every part on this firearm, which would mean that essentially nothing on this firearm would be protected by the Second Amendment. Allow me to illustrate that using this firearm. Now, in oral argument, I asked California's counsel if their argument meant that the sights on this firearm are not protected by the Second Amendment. And part of the reason I'm making this video is because it didn't appear that counsel understood what I was asking. So take a look again at this handgun. What you see on here are iron sights. You have a front and a rear iron sight. And the way that you fire this handgun, the way you aim it is you take and you line up these two sights and you line them up on what you want to shoot at. And that's how you hit what you're aiming at with this firearm. These are iron sights. They're probably the most common sighting system for a handgun. But all you have to do on this particular handgun to change out the sights is remove two screws in this slide right here, and the back sight comes off. And when you do that, you can put the two screws back into a red dot optic, and now you will have a firearm that instead of having iron sights would have a red dot optic. Let me illustrate that by just taking a slide where I've already installed the red dot optic, and here you go. See, so now you have this back iron sight's been taken off, and here's a red dot optic. Now,
by the way, give me a bunch of ones for Judge VanDyke. What a cool judge, man. This guy knows what he's talking about. I love his choice in firearms. Look at this ported. It looks like a HK, if I'm not mistaken, just based on the nomenclature. What do you guys think it is? But you see it's got the rail, the light rail at the bottom. It's got a ported, maybe not ported, but it's got a ventilated top on the slide to keep it cool and light. Looks like a full size, probably a 45. He's also got the holographic sights on it, which of course a liberal would say is dangerous and unusual, right? Because it makes it more accurate. So anything that makes a firearm more effective to defend your family against all enemies, foreign and domestic, remember that it's the Democrat judge who has decided that they think that that's dangerous and unusual, and only law enforcement should be able to have that type of a firearm. That tells you pretty much everything you need to know about why it's a good idea to become a libertarian.
In the hands of an experienced shooter, this red dot optic allows you to shoot the firearm more quickly, to get on target more quickly, to hit what you're aiming at, be more accurate. And so it's obviously much more dangerous if it's being used for an unlawful or wrong purpose. But if it's being used for a lawful purpose, then it makes the firearm better for that intended purpose. So this firearm would be better for self-defense or competition, recreational shooting, or hunting. And indeed, my own self-defense handgun, which this is another P320 that's been configured slightly differently, has a red dot optic precisely because it makes the firearm.
See, now here's where I would disagree with the judge. That's a SIG. I'm not a big fan of SIGs. I think they're a little too heavy, especially for an EDC or everyday carry, if you prefer. And I don't like, so when I'm trying to pull my EDC out, those holographic sights, they grab on your clothes, and I just don't like them. Now, I do like the fact that this is not, it doesn't look like it's a striker. It doesn't look that way. It might be, but I'm not a real fan of SIGs, but hopefully it's got a safety on it. I have a problem with strikers that don't have a safety, because I really don't want to ever have a round chambered, because there's too many times where you're putting it back in your holster that a round could go off. If that trigger catches on something like in a traditional Glock, a round could go off. I've got a problem with that. I think that you should have some kind of a thumb safety on that bad chicken, just in case, because if you got a round chamber, you got a hot round, there's a real problem. Now, the downside is obviously also with a striker that doesn't have a safety, is that you can't have 10 in the mag and 1 in the hole, so 11 rounds, for example. So, there's less capacity. The main thing that a gunner or a self-defense advocate wants is more rounds, because we know that when you're under pressure, you're running, you're jumping, you're rolling on the ground, you're trying to avoid rounds, your heart's beating fast, stand by, that you're not in a position to where you're going to be as accurate. So that means you need more ammunition capacity to get rounds on target. Now, a leftist judge or a progressive liberal, when you talk to them, well, all you need is just 10 rounds. Anything else is dangerous, right? So that's kind of the argument that you're going to be facing when you deal with these guys. It's not reality. And the reason why they make these arguments, well, number one, they just hate guns. But number two, they've never actually been in a situation, a real life situation, where they've been in a gun range, they see what it's like to run in place and then try to shoot. Try running in place for like 5 or 6 seconds and then draw on your weapon and see if you can get rounds on target. All right. Good luck. And what if your target's moving, right? What if the guy coming at you is zigzagging? You need more ammunition in order to put rounds on target. And that's why none of these magazine capacity laws apply to law enforcement, because law enforcement knows that you need more storage capacity for your ammunition. But so far, I'm very impressed with this judge's firearms knowledge. I just disagree with the holographics for an EDC. I think holographics are great for my car gun, for my house gun, right, or a gun at the range. But I think you need to have iron sights, probably with the glow-in-the-dark sights. Oh, man, I keep forgetting what they're called. But you know what I mean. You guys know what I'm talking about. Trijicon. I think you can have Trijicons on there, and I think you'll be just fine. And me being a Marine, I grew up on iron sights. So you just need to learn on irons. You need to always assume that your holographics are going to fail anyways. And they're just basically like, they're not your go-to. You got to always learn the basics. Like, I believe when you drive a car, you should learn how to drive a manual first. So I believe the same way about my firearms. Now, Sinful Toaster says, I'm just agreeing with one thing because it falls in line with your beliefs. Well, I agree with, I don't know if you're talking about me in particular, but I love Sinful Toaster, so don't think that I'm trying to single him out. But no, look, being a libertarian, I don't have to agree with everything that the left says. I don't have to agree with everything that the right says. Remember, I'm a recovering Democrat. I was a Democrat before they started supporting drag queen story hour and trying to tell little children that little boys, they might be a girl. I was a Democrat before Democrats started putting tampon machines in the boys' room and wanting grown men to compete in women's sports. I'm one of the original Democrats when they actually used to wave American flags instead of burning them. So no, I'm able to take parts of both parties and be able to look at it objectively, what I support and what I don't support. Give me a bunch of ones if you think that that is a critical thinker philosophy and better than just supporting one belief over another, rather than just like my belief is, well, take what works and only focus on that. Don't be entrenched in a position that's unreasonable, because it's unreasonable for anyone to think that it's normal for a grown man to dress up like a woman and dance around with fake boobs and a pantyhose and a swimsuit on and dance around in front of little children. It's ridiculous. Give me a bunch of ones if you agree. That's unreasonable. So anyways, let's get back into the show.
Better for its intended purpose, that is self-defense. It makes it more accurate more quickly and shoot more quickly. Now, so in that sense, this red dot optic is just like this magazine. It makes the firearm more dangerous when it's misused, but it also makes the firearm work better for its intended purpose when it's used properly. Well, you may think that's pretty intuitive about the sighting system for a firearm, but the same thing is true about basically every part of this gun. Let's take a look at a part that's maybe a little less intuitive, which is that takedown lever that I talked about earlier. This little piece here, it's necessary for the operation of the firearm. It's a tiny little piece that you need to have for the firearm. And so you would think, well, since it's necessary, then it must be an arm protected by the Second Amendment. But not under California's logic in this case. See, you can replace this factory takedown lever with a different factory takedown lever. This one's called a gas pedal. And when you do that, you replace it, you put the slide back on. Now the firearm is a lot more controllable under recoil. You can, just like with the red dot sight, you can do faster follow-up shots. You can aim the gun more quickly, and you can control it better. So again, as with the red dot sight, as with the higher capacity magazine, this particular takedown lever makes the gun more dangerous when it's misused, but also makes the gun more effective for its intended purpose when it's used properly. So under California's logic, because this is an accessory, this little takedown lever, it could be replaced with a worse part. This little takedown lever is not protected. It's not part of the arm protected by the Second Amendment. Well, you might ask yourself, well, what about the grip? Like, you think this grip, certainly it must be part of the arm. I mean, it seems like that's a pretty key part of a firearm, is the grip of a pistol. Well, actually, under the majority's argument, it would not be protected. And the reason is, here's a bunch of grips that I've accumulated over the years. I'm just going to pull a couple out here. This is a nice small grip, a nice small light grip. This is a big heavy grip. So what you can do on this firearm is you can remove the slide, remove that takedown lever, take what's called the fire control unit out of the firearm. This is actually the firearm under the ATF's definition. And you can take this fire control lever and you can put it inside this smaller grip. And you could use this grip for, say, self-defense purposes, because it's very concealable, it's light, it's easy to carry. And indeed, you'll see that's pretty much the type of grip that I have on my self-defense firearm. Or you could take this much heavier grip with aggressive stippling on it and with a flared mag well, and you could put this fire control unit in there, put the takedown lever on, and then you put the slide back on, and now you have a firearm that is much better at being able to take quick follow-up shots, hit what you're aiming at. And so this grip, all of these grips under the majority in California's logic, could be banned, because if they were misused, they would make the firearm more dangerous, and you could put a different type of grip on if you wanted to. So you might ask yourself, well, what part of this pistol would be protected as an arm under the majority's logic? Well, I suppose California would eventually be forced to say, well, this part, the FCU, I guess, is the arm protected by the Second Amendment. Every other part that you added, as I've just shown you, every other part that you added, could easily be characterized, just like the magazine, as an accessory that you add to the firearm, and therefore could be banned under the Second Amendment, but not so fast. Even this part, the FCU, the core basic part of the firearm, could be banned under the majority's rationale. And the reason is, let me show you another FCU. This is the FCU for my competition gun. It has a really nice trigger, a nice light, crisp trigger, and has some parts replaced in here. It makes for a really nice trigger. You can upgrade the trigger to make it much nicer. And so because of that, under the majority's logic, you could even ban this FCU, or at least most of it, as simply an accessory, and now protected by the Second Amendment. Now, most of what I've shown you could, I suppose, be conceptualized as upgrades. You say, well, that's an upgraded trigger, and that's an upgraded.
Hey, so far, I love this guy. I've never seen a judge that has this advanced knowledge of firearms. And you can see why it's somebody who actually knows what they're talking about when it comes to firearms would vote against this abomination of a decision, this en banc abomination of a decision that just came down. Let's keep listening.
Takedown lever, and that's an upgraded grip. But the majority's logic works both ways. I've just shown you how you could easily improve the sights, how you could easily improve the takedown lever. You can improve the grip and the trigger. You could do the same thing with the barrel. But you could easily downgrade all of these factory parts of the handgun to make the firearm less accurate and slower. You could put in worse than factory trigger. You could require worse sights than what it comes with from the factory. You could require a grip be put on that hurts the speed and accuracy. Indeed, this type of downgrade is precisely what the majority is actually requiring in this case. As we mentioned earlier, this comes from the factory with a 21-round magazine, or it comes with a 17-round magazine in a slightly different configuration. But the majority is requiring that these factory standard parts be replaced with worse than factory parts, a 10-round magazine. So when we take everything off that the majority might call it accessory, what we're left with at best is this fire control unit. And as I've explained, even that could be dumbed down so that much of this fire control unit would be an accessory under California's argument. And of course, you can't shoot this, right? It's inoperable. You need all the other accessories that I've been describing in order to make this work as a firearm. But of course, also each of these other pieces, just like this magazine, could in some way be considered an accessory, since they could be replaced with a different part that would be less useful and make the gun less dangerous if misused. And that could be said for pretty much every single part of this handgun. And the same problem with the majority's argument applies to other aspects of the firearm that are less easily shown in the video, including fundamental aspects of how this firearm operates. At oral argument, I asked California's counsel why California couldn't ban the automatic cycling mechanism altogether under the California's argument. And again, I don't think he understood what I was talking about. Well, this handgun uses that mechanism. This uses the automatic cycling mechanism. And this semi-automatic auto-loading operation is the most popular mechanism that exists today and is used for self-defense. But other mechanisms exist for handguns, including probably most obviously the revolver mechanism. Here's a revolver. Think of the 6-shooter from the old Western movies, right? You can have a revolver, which is not automatic. Or you could have, and there's different types of revolvers. There's single shots, there's double actions. You could have the lever action, you could have a pump action, you could have a single shot break action, which only has one round. You have to open it up and manually take the round out and put another in. And under California's argument, because any of these single types of mechanisms are not essential to make this handgun work, and thus, or make a handgun work, and thus are not an arm under the Second Amendment, California could ban the whole semi-automatic mechanism altogether, thereby effectively banning semi-automatic handguns altogether, forcing everyone to use revolvers or single-shot handguns or worse. And of course, with bad sights, crazy heavy trigger pulls, a terrible grip, you get the point. Ultimately, California's argument, which the majority has unwisely adopted here, is based on the unstated assumption that there's some basic, I guess, unadorned, without any accessories firearm that would be protected as an arm under the text of the Second Amendment, but everything else is merely an unprotected accessory that's been added to that firearm that's unprotected. And I hope you can tell from this video that that idea is simply unrealistic. It could never be applied in real life. Like many of this court's ideas about the Second Amendment, it stems from a basic misunderstanding of how firearms work, combined with a highly unrealistic idea of how such a rule would be administered in real life. Ultimately, the only rule that makes sense and comports with reality and the text of the Constitution is that the entire handgun here, including the grip, this takedown lever, the slide and barrel, the sighting system, and this magazine are all part of the arm within the meaning of the Second Amendment. Thank you for watching.
Sorry about that, guys. I just had one of my buddies on the other line with me. So hopefully you guys got a kick out of Judge VanDyke, right? What a cool judge. And look, I know there are so many people, oh, but how dare you like that judge? He probably supports X, Y, and Z. And I'm like, look, man, I'll take what I can get. I'm not all or nothing, okay? Well, I am a single issue voter. I vote Second Amendment pretty much because that's the only thing that matters to me. At the end of the day, if the zombie apocalypse comes, I know that I'll be armed and ready to defend my wife and children, which is my primary obligation as a man. Everything else is irrelevant, okay? So yes, I'm going to take what I can get. If that judge has made wrong decisions on other cases, I don't really care. He made a great decision on this case, and he even gave us right in chambers. Give me a bunch of ones for that judge to have the balls at the leftist Ninth Circuit, many would call the far left Marxist Ninth Circuit, right? To bring a bag of freaking firearms and firearms components and dump him all over his desk. That was cool. Give me a bunch of ones for the judge. I'm going to go ahead and share his dissenting opinion video right now. And, I have not gone over Lane Meyers yet. I was saving that because I really, really wanted to cover that, man. Now, the next one I'm going to cover is another example of how we're lied to by the Marxist-run news media and how people just believe anything that they hear in the press, okay? And this has to do with how whenever anybody reported a lab leak in Wuhan, automatically you were called a racist because that's what the left does, right? If they disagree with you, you're automatically a racist, right? In fact, it doesn't even bother me anymore because I know that means they're losing their argument. They always engage in ad hominem attacks whenever they disagree with you because they can never, ever win on substance, ever. Give me a bunch of ones if you agree. So what we'll do is we'll get into the Wuhan Lab thing, and you're going to, thanks, you got to go, you're going to Quiet Riot. Hell yeah, man. Right on, Rhine Labs. I love Quiet Riot. Are those the guys that say, come on, feel the noise, girls rock the boys, yeah, yeah, yeah. I think that's those guys, right? Yeah, that was a great band, man. 80s all the way, brother, right? So yeah, hell yeah, man. Yeah, man, I've seen Motley Crue, seen what are the German band. Man, I'm so old I'm forgetting names now, but you know what I'm talking about. Anyways, I've seen them. I've seen Van Halen, a lot of punk bands, GBH. I've seen Susie and the Banshees, Public Image Limited, all the cool punk bands from the 80s. And I've even seen, what are those guys? Leibach, and then the one that came after them, Du hast mich. Those guys, I've seen all those guys, man. I love that stuff. So super, super happy for you, brother. Yeah, Rammstein. Rammstein. Yeah. Those guys are cool, man. In Rammstein, they have so much pyro, whatever you call it. It's literally hot. You can feel the flames. Deinen Flammen, ja. Super cool. Hey, Foreigner was pretty cool too, man. I just love all those old 80 bands. Real music, 80s and 90s, real music. Nothing like we have now. Definitely was the good stuff when you had real musicians playing instruments, not doing all the electronics. But I like electronics, but you know what I mean. Like, it was just better, man. Susie, I love Susie. Spellbound, what a great song. What's the other one? Israel, super cool song. Happy House is badass. But yeah, I've seen Metallica, all those guys. So yeah, man, I'm with you, bro. Go have fun at your concert. That's a once in a lifetime experience to see an original 80s heavy metal band. So that's super cool, man. Hey, Pink Floyd too, Sinful Toaster. I agree. Super cool band, man. Really good stuff. Super happy I got people in my audience that know about real music. All right. So let's get into really quick, because guys, I am working still. I got to get this letter. I'm doing some objections to an advocacy letter as I'm talking to you guys. So I'm going to put you on mute. I'm going to play this next video about what happened at the Wuhan lab. Hopefully I don't get banned by YouTube, because you know that anybody who goes against that narrative by their sponsors who pay them a lot of money at the World Health Organization gets into a lot of trouble. So I got to be real careful about what I say, but I'll play this video. It looks like they haven't been banned yet, so it must be okay to have on YouTube. And we're going to learn about what really happened and all the lies, just like we were lied to about the Hunter Biden laptop in order to help rig an election, right? Now you're going to find out about the origins of this thing, right? Because I don't want to say the name, because you get in trouble if you even mention it, because Big Pharma might lose billions of dollars, right? If you know about what's really going on. But we'll listen to this video, we'll watch this video, and you guys can decide for yourself what you want to believe.
Come see us on tour in Hartford, Connecticut, Syracuse, Atlantic City, Levittown, Cohost, Providence, San Jose, Toledo, Ohio. Go to jimmydore.com for tickets. The New York Times has finally admitted that everybody lied to us about COVID. And Matt Orfella caught this. He says, ladies and gentlemen, I give you New York Times COVID-19 reporter. Someday, this is from 2021, someday we will stop talking about the lab leak theory and maybe even admit its racist roots. So that's right. It's racist to say Chinese have labs, I guess. And that's why Jon Stewart got in trouble with his friend group and had to atone for his racist lab leak theory by hanging a medal on a Nazi. And her name is Aporva? Is that short for Apor vagina? What is that?
It can't be good.
Come on. So that's 2021. Remember when facts were racists?
Yeah, facts were racist. My best friend, I said that to my best friend, and I said, did you hear about this lab? And she's like, that's racist. It's racist to say that. Do you see how much anti-Asian sentiment there is out there? Yeah, because the news puts it on purpose. But anyway.
Facts are racist. So here's the headline from the New York Times. We were badly misled about the event that changed our lives. No, we were lied to. We weren't misled. And this, even though they're admitting all the lies, they don't call them lies. They call them, being misled. Wait till you see it.
We didn't know and stuff like that.
Wait till we get into this article. Hopefully will piss you off. A miracle has happened. The New York Times ran an op-ed acknowledging not only that the COVID virus originated in the lab, but the government officials and scientists conspired to keep the substantiating evidence secret. The lab leak theory was censored on social media because of pressure from the administration. We shouldn't have done it. Okay, just so everybody knows that. So here's from I'll read some of it from the article, right? So in 2020, when people started speculating that a laboratory accident might have been the spark that started the COVID-19 pandemic, they were treated like kooks and cranks. Many public health officials and prominent scientists dismissed the idea as a conspiracy theory, insisting that the virus had emerged from animals in a seafood market in Wuhan, China. And when a nonprofit called Eco Health Alliance, which is a CIA cutout, lost a grant because it was planning to conduct risky research into bat viruses with the Wuhan Institute of Virology, research that, if conducted with lax safety standards, could have resulted in a dangerous pathogen leaking out into the world. No fewer than 77 Nobel laureates and 31 scientific societies lined up to defend that organization. So when the Wuhan research was, the Wuhan research was totally safe. And the pandemic was definitely caused by natural transmission. It certainly seemed like consensus. This is the New York Times talking.
Yeah.
We have since learned, however, that to promote the appearance of consensus, some officials and scientists hid or understated crucial facts, misled at least one reporter, meaning they lied, orchestrated campaigns of supposedly independent voices, and even compared notes about how to hide their communications in order to keep the public from hearing the whole story.
Yeah.
And as for the Wuhan laboratory's research, the details that have since emerged show that the safety precautions might have been terrifyingly lax. Might have been?
I heard they were like a dental office, but anyway.
This is
Yeah.
why haven't we learned our lesson? Maybe because it's hard to admit that this research is risky now, and to take the requisite steps to keep us safe without also admitting it was always risky.
Mhm.
And perhaps we were misled on purpose. Perhaps. Even though that we have tons of evidence that they were lying to us.
Yeah.
This New York Times reporter still says perhaps.
Right. Right.
Take the real story behind two very influential publications that quite early in the pandemic cast the lab leak theory as baseless. By the way, this writer is pretending that she wasn't in on it,
Mm.
right?
Or that she didn't report what she knew at the time. Because if I knew, she knew.
Right, that's right. I knew it.
You knew it.
How did I know it? How did Joe Rogan know it?
We read something.
That's right. It's kind of like when Jake Tapper wrote a book on the Biden dementia cover-up. That's what this is. The first organization was a March 2020 paper in the Journal of Nature Medicine, which was written by 5 prominent scientists and declared that no laboratory-based scenario for the pandemic virus was plausible. But we later learned through congressional subpoenas of their Slack conversations that while the scientists publicly said the scenario was implausible, privately, many of the authors considered the scenario to be not just plausible, but likely. So Dr. Fauci and those scientists who wrote that article, The Proximal Orange, they were lying. They were lying to us. And anybody who questioned their lies was called a racist.
And your career was obliterated. And he sent those emails of how to squash this information, which have been covered, like by Jim Jordan and those Congress
That's right.
hearings and stuff like that. Yeah. Yeah.
So,
And Peter Daszak, the guy of Echo Health Alliance, was part of the WHO investigation into the lab. They sent 6 people into that lab, sent them in there. They looked around. And you know what they said? Nothing to see here.
Nothing to
and you know
see.
what the news reported? Lab leak unlikely. And that's what was reported.
It's weird that I knew this 5 years before the New York Times. Isn't that weird?
And me. And I didn't even have an editorial job. And I read it. And then when I looked into it, I saw other articles and proper papers confirming this. You know, that virus didn't even come from Wuhan. That type of bat is in the Yunnan province, which is 1,000 miles south. They don't even have that type of bat.
So one of the authors of that paper, the evolutionary biologist Christian Anderson, she wrote in her Slack message, the lab escape version of this is so friggin' likely to have happened because they were already doing this type of work, and that the molecular data is fully consistent with that scenario. That's what the scientists were actually saying. But they were saying something completely different publicly. Fauci was lying to you. The New York Times was lying to you. The Lancet was lying to you.
Yeah.
Nature magazine was lying to you.
Yeah.
They were lying to you. They weren't misleading.
It's so unbelievable, though.
And still nobody's upset that they were lied
Nobody's
to.
upset.
Nobody I know who votes Democrat is upset that they were lied to about COVID, the biggest thing that ever happened.
I still don't understand why you don't have mainstream doctors on your show.
I had a guy come on my show and said, Jim, you should bring more mainstream doctors on.
Like who? Peter Hotez?
You're right. Spooked, the authors reached out for advice to Jeremy Farrar, now the chief scientist at the WHO.
Oh.
In his book, he revealed he acquired a burner phone.
Oh. What is he?
And he arranged meetings for them with those scientists who were writing that paper to lie to you. So this guy at the WHO, he got a burner phone, and then he arranged meetings for those scientists with people like Francis Collins, who was the head of the NIH, and people like Anthony Fauci. He got a burner phone.
Like people are using Slack and getting burner phones?
Burner
this is
phones.
What they're doing? This is what people do who, like the Ashley Madison people, right? Like this is what people do who want affairs, to have affairs.
I think every trusted authority in the health industry should be caught using a burner phone. Nothing says integrity more like a burner phone. And the New York Times still refers to it as perhaps they were misleading us on purpose. They were using burner phones.
Yeah.
And they were saying
they don't want to get busted. It's clear as day.
That's as clear as day.
Yeah.
Documents obtained through public records request by the nonprofit U.S. Right to Know show that the scientists ultimately decided to move ahead with the paper. So they ultimately decided to lie. That's what that's what I can rewrite that for this writer.
Yeah.
So operating behind the scenes, Farrar reviewed their draft and suggested to the authors that they rule out the lab leak theory even more directly, and then they complied. So they just knowingly lie. So again,
right.
You think that scientists and doctors have some kind of integrity? They can be bought just like anybody else. Just like anybody else, they're bought off. And so what this woman doesn't write in this article is that Dr. Fauci gave them like $8 or $9 million in research grants, and then they completely flipped their story.
Right. Ka-ching, ka-ching.
Yep.
Yeah.
Anderson later testified to Congress that he had simply become convinced that the lab leak, while theoretically possible, was not plausible. Later, chat logs obtained by Congress show the paper's lead authors discussing how to mislead this guy, Donald McNeil Jr., who was reporting on the pandemic's origin for the New York Times. So they all got together. Hey, how do we lie to the New York Times? This is Dr. Fauci, all those people. So as to throw him off the track about the possibility of a lab leak. Wow, what a bombshell. I mean, it was a bombshell when I reported it 2 years ago.
You've known this for a long time. We've known this. I've known this for a long time.
But good news, Anita, and to all my liberal friends, you have permission to believe the truth about the lab leak now, because the New York Times is saying it's okay.
Yeah, in their very gentle way.
Yes.
And the way that they phrase it, that is going to elicit the response. Hey, well, it could have been. And so this is what happened. And so then people go, oh, and nobody goes, you made me do what? You made me take this injection and now I have and I'm not supposed to be upset about it. And I couldn't go to my grandma's funeral. All those things, right? That people still are not. What's it going to take to make you upset?
Yeah. How many of you are still believe anything that the leftist run press, bought and paid for by Big Pharma, said about what happened? How many of you didn't get to bury your family members? How many of you were forced to be by yourself and ostracized by others? How many of you in the military who stood tall for your rights were forced to be discharged and lost all your pay and your career because you stood for what was right in the eyes of your family, yourself, and in God's eyes? And how many of you aren't ashamed of yourselves for saying that you should be forced to take this experimental thing? How many of you aren't ashamed of yourself? The same people who said, my body, my choice, now that you know you were lied to, are you going to change your position? Is cognitive dissonance going to prevent you from doing the right thing now and repent for your sins? I want to know. I want to hear what you guys have to say. Give me some comments in the sidebar.
Set.
So here's Peter Daszak.
Yeah.
So
yeah.
He's the very evil guy, and I'm going to tell you why he's evil. Thanks to public document requests by the U.S. Right to Know, the public later learned that behind the scenes, this guy, Peter Daszak, EcoHealth's president, had drafted and circulated the letter while strategizing on how to hide his tracks and telling the signatories that it will not be identifiable as coming from any one organization or person. So they wanted to push this theory that the virus didn't come from the lab that they were funding. He wanted he wanted to push this theory that it didn't come from the lab and then hide his tracks that they were the one behind pushing it. That guy, Peter Daszak. Criminal.
That's like having an affair and then having a shower. I want to cover my tracks, right? Okay.
The Lancet later published an addendum disclosing Dazzik's conflict of interest as a collaborator of the Wuhan lab, but the journal did not retract the letter. They never retracted the proximal.
Their whole job is to publish proper literature in a journal.
And they had assistance. Thanks to more public records requests and congressional subpoenas, the public learned that David Morens, a senior scientific advisor to Anthony Fauci at the National Institute of Health, wrote to Daszak that he had learned how to make, quote, emails disappear, especially emails about pandemic origins. So Fauci's right-hand man was telling Daszak, don't worry, I figured out how, we all know how to make emails disappear, except we found it.
Yes.
We're all smart enough to know to never have smoking guns, and if we did, we wouldn't put them in emails, and if we found them, we'd delete them. These are the scientists running the COVID program.
But Jimmy, okay. Is there more with this?
Yeah, there's a little more to this.
Okay, then I'll hold.
So here's how the New York Times then tries to soft sell this and bullshit you. It's not so what they just described was unbelievable criminal evil actions taken by the top scientists handling COVID. Anthony Fauci, Collins, Daszak, and the people who wrote that paper. It's not hard to imagine. Just listen to this. It's not hard to imagine how the attempt to squelch legitimate debate might have started. Some of the loudest proponents of the lab leak theory weren't just earnestly making inquiries. They were acting in terrible faith, using the debate over pandemic origins to attack legitimate beneficial science, to inflame. So the people who were right, she's still slandering. The people who were right about the lab leak theory, she's still saying they're horrible people. That's what she's doing.
She's saying they're acting in terrible faith.
The woman who wrote this article for the New York Times is saying that the people who were right about COVID are still lying, horrible people acting in bad faith. Isn't that amazing?
To inflame public opinion. Bull.
Or maybe they were just trying to get to the truth, which is what the New York Times does 5 years later. For scientists and public health officials, circling the wagons and vilifying anyone who dared to dissent might have seemed like a reasonable defense strategy. What? You mean the liars and criminals are the reasonable ones?
Right.
The people slandering and discrediting people seeking the truth, they're the reasonable ones, but not the people who were
being vilified.
Yes. That's also why it might be tempting for those officials or the organizations they represent to avoid looking too closely at mistakes they made. They weren't mistakes. They were lies. That's why they had to delete their emails. Yeah. That's why they had to use burner phones, because they were up to a criminal conspiracy.
Yeah.
And while trying to do such a hard... So that's also why it might be tempting for those officials or the organizations they represent to avoid looking too closely at mistakes they made, and at the ways that, while trying to do such a hard job, a hard job of covering up their lies.
Yeah, exactly. Well, we don't want to look too closely.
That's why they might have withheld relevant information and even they did. It's not might have. They did.
They did.
They lied.
They did.
And the person who wrote this for the New York Times is a garbage person.
Yes, because she's trying to.
Because she's still trying to mislead you.
Yes.
She's misleading you in an article about how we were misled.
She's shaping your opinion.
Yes. Yeah. She's spinning.
Yeah.
Such self-scrutiny is especially uncomfortable now, as an unvaccinated child has died of measles. So she's pushing the propaganda about measles.
Yeah.
Can you look up see if that kid was vaccinated? I bet that kid was vaccinated. The measles death, see if that kid was vaccinated. And anti-vaccine nonsense is being pumped out by the top of the federal government. So she's still doing it.
He's still doing it.
The nonsense is the hysteria that's surrounding the measles.
Yeah.
That's the nonsense. But
the nonsense. Yeah.
Go ahead.
Well, the nonsense is perhaps maybe what we've been told about vaccines our whole lives is not really the truth of the matter. Because I believe it kind of died out in 1968 because of good hygiene or better diet or something. We didn't need this damn vaccine, did we, in the first place? And I think we've been led to believe it's the one thing you can't question. Don't question anything you can't question is the thing you should be questioning.
Well, I have to correct you, Anita.
Sorry.
The vaccines are totally safe and effective and very needed. If you don't have a vaccine, you're going to have measles.
You're going to have measles, and you'll get to stay home like the Brady Bunch kids did or whatever.
So we can't decide. I just have to correct you on that.
But I do want to say you know how everybody goes, oh, polio, and look at what it did to polio. I have somebody in my family that has polio, and my mom said they got the polio vaccine when they were little girls.
That's anecdotal. Here's my last slide. But a clumsy, misguided effort like this didn't just fail, it backfired. You think? You mean lying at every turn, using burner phones, deleting emails, bribing scientists to tell lies? You mean that might have backfired?
You think you might have got caught?
It was a misguided effort. No, it wasn't. It was guided.
They didn't know.
They did it on purpose.
Mm-hmm.
You piece of garbage New York Times op-ed writer. These half-truths and strategic deceptions made it easier for people with the worst. So again, someone else is worse than these people she's describing. There's someone else worse than the lying, than Fauci and Collins and Daszak and all the people who lied to us about COVID. Other people are worse. They have the worst motives. Well, what motives did they have? The people who fucking lied to us. What was their motives? Their motives was to pull off a criminal conspiracy.
But beyond, yeah.
These half-truths and strategic deceptions made it easier for people with the worst motives to appear trustworthy while discrediting important institutions where many earnestly labor in the public interest.
Oh.
Look who, and this is here's the garbage person who wrote that.
Zeniyep Tafuki?
Whatever
her name is?
Look, at the end of the article, there's a fun word scramble.
What is this? Sudoku or something? Her name?
Did a cat walk across the keyboard or something? What happened?
Her parents were drunk and they just typed on the keyboard and no, I don't know. I'm not trying to make fun of her name, but that's a garbage article. You're absolutely right.
Garbage article.
And what is in it for her to publish an article like that? Because you get your stupid,
because she's a part of the establishment. That's why. That's why.
But who cares now? Move on. Go to Substack. Look at Mike Taibbi. Write something good.
She's there to let you know that the New York Times is still lying to you. We're never going to stop. Even when we tell you some of the truth, we're still going to cover it up with bullshit. Yeah. That's what she's doing. Show her again. Show
sugar-coated all that. Yeah.
That's who that is.
It's sugarcoating one of the worst things that have ever happened to humanity. And the thing I can't figure out still when I hear you talk about this, I've heard you say many times, people don't give a shit. And I feel the same way, that people do not get angry about this for the injured and for everything that happened. I didn't take it, so I didn't get injured, but people did. And you have every right to be saying this. And what the hell was the government doing this to people?
They lied about
money. It's,
she's not upset. This woman's not. She's still angry at the people who got it right.
Yeah, she's still angry.
She's not angry at. Yeah, she's not angry at Fauci and Collins and Daszak and the entire media. They even lied to the New York Times. So she's not mad. She's not angry at them. She's angry at the people. She's
angry that information makes her a shitty writer and shitty reporter.
That's right.
She should be angry that she wrote that. She should be mad at herself.
That's right.
Yeah. And with all the hygiene that we have, I mean, I don't know if this is going on YouTube or where, but I am still astounded that it could transmit across the world the way it did, coming from that lab.
Correct.
I think Did they spray it? Did they spray it in the subway? You know, what happened? I think a lot of this was psychological. What happened? And it was
Well, we now know that the fatality rate of the virus was minuscule. It was less than 0.5%.
Yeah.
So it had
People
a
were just-
99.7% survivability.
So even when they made it in the lab, they didn't even make it as lethal as they should have. Why don't you just friggin' take us out if you want to take us out?
It was hype.
It was hype. It was suggestion. It was psychological control.
Yep. And she's not mad that they lied to you about transmission. She's not mad that they lied to you about contraction. She's not mad they lied to you about the fatality of the virus. She's not mad that they lied to you about herd immunity, natural immunity, lockdowns, masks. She's not mad about it tonight. She's still angry at the people who like us who got it right from the beginning.
That's right.
And I'm a C student and I got it right. She's a doctorate.
Yeah. I mean, I got it right, and it just fell into my lap because I just opened my eyes and went, "This isn't right. Let me look into this." And I did, and you know, I wasn't even a reporter. You're a comedian, and now you've started this huge news podcast because of it. Because these buggers are not telling you the real deal.
Still,
and anyway, they're completely incompetent. These people at the lab, you know what I mean?
It's a slimy article, slimy person. The whole just slimy.
Yeah. It is slimy. It is dripping it in this kind of syrup, this manipulative syrup to go, hey, it wasn't so bad. And
they were doing the right thing. You couldn't understand why they were just misguided. No, they weren't misguided. They were just like you. You know exactly what you're doing. You're
misguided
right.
To that degree.
Yeah.
No way in hell. Because in Canada, we changed laws. We have something called the Infant Act, which that a healthcare practitioner can give it to a baby if they think that the baby has agreed. So don't even tell me there were never any mistakes being made every step of the way. The American government, the Canadian government, and all around the world, they knew what they were doing.
They were lying.
They were lying. Why? For what gain? Is still a mystery to me. It's still something I can't completely explain. Is it greed? It
definitely was. At least half of it was greed, if not more. Of course, it was hundreds of billions of dollars to big pharma.
I know, but like such lethal greed. Like this is what's going on.
They do war for money, Anita. Come on.
I know that. I know. Like they do. Oh God, they'll look at fentanyl. They'll kill you for fentanyl.
That's right.
Fentanyl is also a bioweapon. You take that, you die, but no one cares. And they'll drip that into the drugs. So if somebody's doing cocaine, they'll die. Like they don't care if they kill you.
They don't. That's exactly the same people. The same people who, you know, that's the WEF. It's those people, the handful of billionaires that run everything and do all the wars and slaughter people. They don't care. They don't care what they did. They don't care how many people got injured. They don't care how many people lost their jobs. They don't care how many families they split up because of this. They don't care about anything. I lost a majority of my friends in Hollywood because I was telling the truth about this. And they'll never admit that they got it wrong. I can forgive them for being wrong about COVID, but they will never forgive me for being right about COVID.
I know if they came up to you and said, Jimmy, oh my God, like I really, really got caught up and I feel deceived. But I just want to say thank you for what you were trying to tell me. I can see it now.
Yeah.
But no, they don't do that. They double down, triple down because they got to go safe and effective. What are you going to do? And that's why you can't have a cocktail party now with your Hollywood friends. It's too awkward.
Yeah, it's okay though. It's all right. They were, those people also garbage. And I'm, in a sense, I'm glad it got revealed.
It got revealed, but God, the psychosis is deep, because there are people that you like.
A lot of people said silly things around COVID. I just wish that they would have, apologize for it. That's all.
Me too. See the light. Get out of the dark side. Look at what happened. And you what's it gonna take? What do we gotta slap you upside? What's gotta happen for you to wake up? What more needs to happen that you don't see?
The people who call themselves, anti-establishment truth tellers they're never going to tell the truth. They don't even want to know this information. They don't even want to know. I bet you won't even read that article. They don't want to know anything. It's kind of amazing. All right, Anita, it's been great talking to you. Great catching up with you. It's always great to see you.
Up with you. It's so great to see you. I really.
All right. So, just another example of how the government-run media, with their friends at the NIH, the CDC, big tech, big pharma, all colluded to disinform you and try to classify you as a crazy person if you didn't go along with what we now know to be a complete lie. So that's why, it's amazing. Everybody says Alex Jones is a crazy person, and he is kind of crazy. But why is it that 99.99% of the time, all of his conspiracy theories are proven true? And I get it. It's more about his delivery, coming off like a crazy person that sort of taints him. And in a similar way, that's the problem that I believe is happening with Lane Meyers. A lot of people, because they've been brought up to think that people who are outspoken, people who might be suffering from a mental disorder like attention deficit, or maybe they're suffering from some kind of psychological trauma from being falsely imprisoned, right? That they're going to be in a position where they may be louder or obnoxious. Somebody with Tourette's, for example, will be ostracized by the court system, by prosecutors, and by the general public. Instead of having their unalienable fundamental rights as individual rights upheld, the majority, aka the democracy, and what is a democracy? It's when two wolves and a lamb show up for lunch and decide what's on the menu. In a republic, it's where two wolves and a well-armed lamb shows up for lunch and contests the vote. And that's why none of our founding documents mention the word democracy. We are a constitutional republic. Almost all of our founding fathers, to a man, spoke up against democracy because they understood that the rights of the majority, the 51%, could overrule the rights of the minority. And that's what I believe is happening in the case of Lane Meyers. So, and I see now Dennis W. says anti-vax cult. I get it, you guys. So let's look at his comment. He says, I feel sorry for the folks in the anti-vax cult. I don't care where it came from. These things work. And obviously he wants me to say that they don't, because he knows that his friends that control YouTube will ban my channel for speaking the truth about what mRNA actually is. If I talk about spike proteins or anything like that, I risk losing my channel. And he knows that, because he knows that the World Health Organization has an exclusive arrangement with Google where anybody who says anything bad about them gets buried to like page 5,000. So it's not going to work with me, Dennis. I'm not going to let you play these games with me. But I appreciate your absurd and stupid comment. Now let's get into what's going on with Lane Meyers, because this is what it's all about. I know this is what most of you came for. So I'm a big time fan of This Is a Public Service, and he did a live today. He may still be live for all I know, but I'm going to go ahead and cover his show, and I'm going to keep working here. And we will, and I will cut in, whenever I can. And any of you guys who want to get rid of the Marxist Democrat Dennis W., feel free to just zap him out of here, because he's got nothing positive to say. He probably is a bought and paid for shill for the leftist NIH-run Democrat Party. So let's get into this next video. Let's go.
I've been selling my soul, working hard.
Before we watch this, though, let me say this. That somebody can make this all stop right now. Judge Doug Metcalf has the anti-slap motion. He can take immediate action. Nothing is preventing him from taking action right now. So I just want that to be known. Yesterday he made the point of saying, okay, he didn't have jurisdiction. All right, well, Lane's been arraigned now. He's got the anti-slap motion. we're going to go through that whole thing. So so we all can be on the same page, and we all can appreciate the gravity of what's actually happening here. So let's watch this arraignment here. But just some food for thought before we go into it. And this is John Stuart Mill in 1867. Let not anyone pacify his conscience by the delusion that he can do no harm if he takes no part and forms no opinion. Bad men need nothing more to compass their ends than that good men should look on and do nothing. He is not a good man who, without a protest, allows wrong to be committed in his name, and with the means which he helps to supply, because he will not trouble himself to use his mind on the subject.
Rachel, you go out the door, sit with me.
Good evening. Can I please have your full name?
Yes, sir. Lane Jeffrey Meyers.
Good evening, Mr. Meyers. You are here on charges of aggravated harassment. 3 charges of aggravated harassment alleged to have occurred between on or about March 13th and March 17th. I understand the private counsel is present on the line.
No, Your Honor, I'm OCAC. I was appointed to his earlier case and surprised at being arrested in court today. Given the situation, that's why I got approved from OCAC to appear this evening, assuming I will be appointed of this one as well.
Yeah, okay. So I will point you to this matter as well. Mr. Parvin, is that good?
Yes, Your Honor.
All right, reviewed the pretrial services assessment, state's recommendation.
Your Honor, Rachel Stiles for the state. Your Honor, he is on felony release. He was released on the 14th of this month to pretrial services. He has 2 of the offenses are felony offenses alleged to have been committed while on felony release. So for that reason, we would ask for him to be held without bond, thus pursuant to Article 2, Section 22, and we would request a no bond hearing to be set.
Your Honor?
Mr. Parvin, go ahead.
Yes, first of all, I was just looking online. It said charging alternate correction. I don't know if the complaint's been filed. I was just only looking at the website, so I wasn't sure if the actual complaint was entered yet or the charge. But regards to that, Mr. Meyers, none of these offenses are violent. They would be bailable as a matter of right if they're all filed at the same time. Mr. Meyers has never missed court. And in fact, this is kind of gotten media attention where there's numerous people posting about it. It's not maybe even across the world based on a YouTube channel. There's multiple people that are making videos. It's not Mr. Meyers. That is the problem. The state keeps accusing Mr. Meyers of felonies that he didn't do if he's not the one who made the video. That's what the trial is for. Next Friday, the court set an evidentiary hearing next Friday on whether Mr. Meyers, in fact, violated any release condition.
So for those of you who are just now getting onto the show, this is a story of Lane Meyers. He is a pro se litigant who has filed multiple civil rights claims against the deep state, the administrative state. And he was going after a public servant, I believe, a law professor, publicly subsidized law school, because allegedly, I believe she had gotten his wife fired from her job as a clerk for a federal judge. And so he was exposing her and what he believes is corruption in the administrative deep state in Arizona with heavily entrenched far left Marxist government employees. And of course, he was always wearing a MAGA hat. So that obviously made him a target. And so now he has been brought up on what I believe are trumped up charges, like 14 felonies, because he did a YouTube show exposing a lot of the things he was unhappy with. And now, of course, he's in jail. So the modern day William Wallace, Lane Meyers, they're trying to say he's violent, but it's other people who are making the videos and talking about it. And Lane, he's just got his personality, and he's brash and bold and aggressive and abrasive, and the courts don't like it. The prosecutors don't like it. And this is why I tell you guys, it's not what you say, it's how you say it. Because even though he's right, look where he is. And that's the point that I've been trying to make to all of you guys. And the Chile de Castro case was another example that if you can be civil, you disarm your opponent. You really do. It hurts them more when you're civil. When you're bold, brash, and aggressive and loud, what it does is it gives them more firepower and gives them the ability to finger point. And since they already believe in democracy and they don't understand the difference between a constitutional republic where the rights of the individual are what matter, because they've been told since birth from public school that, oh no, the democracy, the majority should be able to decide the fate of the one, which is the exact opposite of what our founders want. This is an example of what happens. So I believe you need to play the game by the rules that they have and beat them at their own game. That's just my philosophy. I used to be like Lane. I'm one of these guys who got my camera smashed by the police for filming with the big cameras back then, was falsely arrested and imprisoned, and I won that case and ultimately sued for civil rights violations and won that case, and then ultimately became a lawyer with no law degree or undergrad. And by the way, I'll give myself a plug right now. I have a digital version of my ebook for $19.99. If you go to my YouTube site, you can learn about my journey to becoming a practicing lawyer with no law degree or undergrad. And that's something that I, have been encouraging people like Chile de Castro and Lane Meyers to do. I know a lot of you guys hate lawyers. You have a false belief in this so-called British accreditation registry, which is complete bunk nonsense. Bar has nothing to do with that. It had to do with the common law bar, a chain that went over the castle where the original first lawyers were trained in that castle that had been originally inhabited by the Knights Templar. And then, of course, later, the bar that separated the common law study people who were training under lawyers and judges, like what I did, from the actual admitted bar members. And then you would pass the bar once you passed the test and you became a practicing attorney. That's all it was. So anyways, that's why I believe that you need to follow that approach. Because if you don't know the law and mean to keep it well, like St. Thomas Aquinas said, just like Ben Franklin said, if you don't hang together, you'll surely hang separately. You've got to hang together in an organized group of jurists, and I'm forming an alliance of patriotic lawyers across this country so I can help people like Lane and other people who are misunderstood and falsely imprisoned. And that's a story for another day. But let's get into the story of Lane Meyers. Now he's talking from jail, trying to advocate his case. Imagine being in prison, no access to a computer, no way to do your briefs anymore, arrested outside of a hearing where you did appear, where you've never, ever not appeared. You've never been a flight risk. And all of a sudden you got two cops waiting for you outside the hearing room after you just did a motion to be able to represent yourself, a Faretta motion. So now they know, the prosecutor knows, oh, we'll just throw him in jail. How is he going to be able to do anything? It improves their posturing. It improves their ability to beat him. Imagine the psychological stress he's under, knowing the guards hate him, knowing that the cops probably have said negative things about him to the correctional officers. And now he's got to be in a position where he's not going to have much of an opportunity to defend himself. I think this is a travesty of justice. Give me a bunch of ones if you agree. Let's get into it.
Or did anything the state's alleging now. It was quite a surprise to be picked up on new charges when we have this hearing next Friday to determine whether there's any basis or not. With that in mind, Your Honor, Mr. Meyers also got permission to proceed pro se for that hearing. He needs to prepare for that hearing where the state's going to present videos and evidence next Friday. It's already set. There's no threats of violence or anything. Mr. Meyers is not a threat to anyone. There's no reason why he can't be released. And then go to this hearing on Friday. And if the state proves their case on Friday, where there's more likely than not for a purpose of that evidence you're hearing that these offenses were committed, then yes, at that time, Mr. Meyers can be brought into custody next Friday. But if they can't, well, that's the real problem. And certainly right now, Your Honor, it's given the fact there's no violence alleged, and there's so many people involved here on YouTube and doing things that Mr. Meyers may or may not even know about. It's not really fair to keep him in custody, Your Honor, when he's gone to every single court date. He hasn't missed anything. He submitted his own motions explaining why He thinks this case is unfair to him. All we're asking for, Your Honor, is to maintain the current hearing of next Friday where this all gets settled, and then Mr. Meyers be released with any conditions the court determines, maybe obviously no contact with the victim. That's not going to happen. Given the situation, maybe the court for at least 1 week could order Mr. Meyers no participating in any YouTube videos, whether it's his own or a third-party video, just no doing interviews, at least for 1 week. I think okay, Mr. Meyers, until we get that hearing next Friday. That way, if anything does happen, we know it's not Mr. Meyers doing it. And that's what I think would be fair, Your Honor, if you offer release conditions, because even though there is an alleged felony on pretrial release, if you look at the standard, you have to find there's enough evidence right now that it's a great likelihood where the felony was committed before you can make it non-bailable.
So, Your Honor, Rachel Stiles, again, that is not correct. The court does not have discretion tonight to do anything other than to hold him no bond. He is then entitled to a no bond hearing. And then at that hearing, then the state will put on the evidence to meet the standard. So for tonight's purposes, it's just that he is alleged to have now committed new felonies while on felony release. So a no bond hearing must be set.
That's not what the rule says for initial appearance, though. The court at least says to find probable cause and go into the bail requirements.
It does.
I'm looking at this, at least the court has at least find sort of probable cause for the complaint, whatever evidence is presented. And then let's go into the next rule on right to release. And that's where it says the court can do that. It has to at least have some evidence why Mr. Meyers would be a danger. The court still has to find a reason why he needs to be held up on tonight.
Yes. The court has.
Thank you both. Identify probable cause to believe that one or more of the offenses has been committed. I will grant the state's request to hold the defendant without bond, set a no bond hearing for March 25th at 2:30 in the afternoon. Mr. Parvins, you are appointed as counsel.
What time is it? Is it March 25th?
March the 25th at 2:30 in the afternoon, sir.
Okay, should barely work.
Why the delay?
Thanks for being flexible, sir.
Being
That's it for
flexible,
tonight,
that's-
Mr. Parvins. You're excused. Mr. Meyer, you're also
Yeah,
excused.
that was yesterday. So that's 5 days away. You know what I mean? Seems a little ridiculous to me. So what I'm going to say right now, I don't know if it's completely accurate. This is what Lane told me prior to yesterday's hearing because he knew this was going to happen. That you heard the judge there. He said,
The court still has to find a reason why.
He says, I'm going to find
The
probable
court still has to
cause,
find
right?
he needs to be held up on tonight.
The court has.
Thank you both. Identify probable cause to believe that.
So he did find probable cause to believe, but and again, I could be wrong. My understanding was that they would actually have a discussion about the probable cause, that he would be able to challenge the validity of the probable cause during this arraignment because of the risk of being incarcerated, right? The risk of taking a man's freedom away. Like, I know that to the Walkers and to Rachel and to Conover, putting somebody in jail is no big deal. They do it every day. They love it. But that's not the way that's outrageous. So no bond until the 25th. And as far as I know, I could be wrong. As far as I know, there's only one person that can do anything about it, and that's Judge Metcalf, because Judge Metcalf has this in his possession, right? And I was reading something earlier. See if I left it open. All right, Arizona amended its anti-SLAPP law in May of 2022 to protect all lawful exercises of First Amendment rights, including the rights of free speech and free press. Arizona revised statute annotated 12-751A 2022. The amendments, which took effect on September 24th, 2022, marked a substantial expansion of the law's scope. Previously, Arizona's anti-SLAPP law only protected against SLAPP suits brought in retaliation for exercise of one's right to petition the government, such as participating in a referendum or submitting statements to a government proceeding. Arizona revised statute annotated 12-751 1 through 2, 12-752A 2019. To invoke the amended statute's protections, the SLAPP defendant must file a motion to dismiss or quash the suit within 60 days. Arizona revised statute annotated 12-751 AD 2022. However, the defendant must also demonstrate that the case against them was substantially motivated by desire to deter, retaliate against, or prevent the lawful exercise of a constitutional right. ID 12-751B. This restrictive requirement is new to the amended statute. A plaintiff is not required to respond to the anti-SLAPP motion, and discovery is not paused unless and until the court finds that the defendant has made a prima facie showing. 12-751BE. If the court finds that the defendant has shown that the case against them was improperly motivated, it must grant the defendant's anti-SLAPP motion unless the plaintiff meets a certain criteria. If the plaintiff is not a state actor, can anybody tell me? Is there anybody involved in any of these cases that are not state actors? Anybody? Is anybody involved in this not a state actor? Tell me the only person involved in this that's not a state actor. Oh, wait. Thank you very much, Cynthia. Welcome in, everyone. I'm sorry. Today is going to be a little discombobulated. Dad.
So basically, a lot of you guys probably don't know what a state actor is, okay? But in civil rights law, we have this concept. I think the seminal case, at least when I was doing a lot of civil rights cases, was US v. Price. I believe that's what it was. And it has to do with a private actor getting state action to violate someone's civil rights. Let's say you have a restaurant and you don't want black people eating there. Or now modernly, right? You have a restaurant and you want to have safe spaces for black people because you believe in reverse racism is a way to get social justice. Okay, let's use a modern example of what they're doing to white people on college campuses. All right, so let's say the college professor, who may not be a state college, but yet subsidized by the state. So arguably they could be an actual state employee, but let's say we agree that a student, let's say that one of these BLM member students who hates white people because they've been taught that all their life, now says, these white people invaded my safe space. So they call the police, and the police agree that you violated their safe space, their segregated space, where no white people are allowed. And the police arrest you, and they now just violated your rights because you're entitled to equal protection. You're entitled to be there. It's, you paid to be at the school. And so now that is called state action. That is where that private citizen can now be sued as a state actor. So in this particular case, that's called the state actor theory. And obviously the police are already state actors. In this case, the prosecutors are state actors. So what Good Citizen's doing here is just asking you who isn't a state actor here. But I just wanted you to understand the nuances of what state actor theory is and what a state actor is for purposes of civil rights law. And this has to do, what he's talking about is the slap motion, the anti-slap, because what Lane did is he filed a strategic lawsuit against public participation in this, I guess, this new scheme in Arizona where they allow you to do it in a criminal case, which is news to me. Like, this is a very new thing. And basically he's slapping back at them refusing to allow him to have a YouTube channel or publicly talk about what he thinks is government corruption at the highest levels in the state of Arizona, and all of the family relationships between all the parties that are trying to come after him, and they're trying to silence him. The same way they tried to silence people who contested the election results. Same exact thing that they're doing. In fact, I think that's how this slap thing got started. Is there was a guy who was talking about all the corruption and all the election fraud that was obvious, overwhelming evidence of election fraud, and it was just ignored by the judicial system. And so this guy they tried to silence this other guy, and he brought this case. And so Lane's sort of doing the same thing, just to give you an idea of what's going on. So let's keep on listening.
He is, I mean, he's certainly behaving as if he is one. I'll say that. So the only person that I'm not seeing it, Randy is right. Yup. Mitten State Media's got it. Yup. Mm-hmm. Yup. That's right. Lane is the only one that's not a state actor. All right, before we, did I finish this? Do I need to? Yeah, I do need to finish this. If a plaintiff is a state actor, they must show that their claims are justified by clearly established law, that they did not, in fact, act to deter, retaliate against, or prevent the defendant's exercise of constitutional rights. Now, how likely is that? How great is the possibility that the state actor is going to be able to show that their claims are justified by clearly established law, that they did not, in fact, act to deter, retaliate against, or prevent the defendant's exercise of constitutional rights? Where is he right now? Where's Lane? Anybody know where Lane is? Where's Lane at? We just watched a video that looked like the Pima County detention center. So, are his rights deterred by the fact that he's sitting in jail? I'm just wondering. Exactly. He's been kidnapped again. If the plaintiff is a state actor, they must show that their claims are justified by clearly established law, and that they did not, in fact, act to deter, retaliate against, or prevent the defendant's exercise of constitutional rights. A higher bar, although not in this case. In this case, the bar might as well be lying on the floor. One must only walk over the bar, making it easier to win the anti-slap motions against the government. In making this determination, the court may hold an evidentiary hearing or consider the plaintiff's complaint, the anti-slap motion, and the sworn statements containing facts on which the assertions in those documents are based. If the anti-slap defendant prevails on his motion to dismiss or quash, the court may, but is no longer required under the amended law, to award the defendant their costs and attorney fees. Conversely, if the court finds that the motion to dismiss or quash was frivolous or brought solely to delay the proceedings, it shall award costs and attorney fees to the prevailing plaintiff. that's an impossibility in this case. If the court finds that the defendant has shown the case was improperly motivated, the court's decision granting or denying the anti-SLAPP motion can be immediately appealed. The appeal will be expedited unless an appeals court rule or decision provides otherwise. ID 12-2101 A5 E 22-261C.
Sinful Toaster makes a comment that if there's a revolution, we won't need lawyers. But, when we had an American Revolution, we still wanted to be English, and we retained our English common law, except where English common law was abrogated by our American sensibilities of unalienable rights. Natural law, John Locke. And those lawyers remained in place and ultimately became the new lawyers and the chief justices of our newly found government. So I think if there was a revolution, that the patriotic lawyers who don't support the World Economic Forum, who don't support the CNN and the Department of Diseducation, the Department of Education, I think that there will be a place for them. I mean, you need to have people who are trained. If there was a revolution, it would simply be to revolve back to our founding beliefs. I think most of the people that would be engaged in a revolution would simply want us to return to the original Declaration of Independence, Articles of Confederation, and natural law. But this time there needs to be stronger laws that prevent bankers from being able to pervert our banking system. Ultimately, it's the Jekyll Island and the federal income tax was the beginning of the end of our freedom as a free people. Give me a bunch of ones if you agree. So I think that there still would be a place for lawyers as long as they're patriots. And I think that should be basically the litmus test for anyone. Are you willing to defend the republic from all enemies, foreign and domestic? If you are, there should be a place for you once they revolve back to the principles of our founding fathers. Agree or disagree? Give me a bunch of ones if you agree. Give me a bunch of twos if you disagree. And if you disagree, tell me why. I'd like to hear why, because there certainly were a lot of lawyers during the Revolution who became lawyers for the Republic. And they were great lawyers. So that's just my thoughts on that. But I'm with you, Sinful Toaster. I can detect the unhappiness and the fear that people have of the administrative state. Public servants have become the master, which is precisely what our founding fathers didn't want. And that's why it's important that we cover stories like Lane Meyers. So let's get back into the video.
These provisions do not apply if the court finds the defendant failed to show the case was improperly motivated. Well, good luck. But let's be clear. There's one person that can take immediate action on this right now. His name is the Honorable Douglas Metcalf. So, we'll go over the hearing, the first hearing from yesterday. I didn't find the judge unreasonable, right? I thought that he could have said to the state, Miss Stiles, are they standing out there to arrest him? She can't say, oh, I don't know. I mean, the indictment would come from her, right? So she doesn't get to stand on that bullshit. This totally corrupt prosecutor. I'm gonna just bring it back down a notch or two. All right, so this was filed yesterday morning. So it's in the judge. Actually, before we do that, before we get into it, because it's going to take us a little while. Let's see. Does everybody know how to reach out and contact Lane. Does everybody know how to leave a voicemail for him? I left a voicemail for him yesterday. We'll listen to the rest of what I sent him. This is I could only send him the beginning. My message was, you're only allowed 2 minutes. But this is what I sent him. This is the balance of what I sent him.
If you can say the word good, guess what? It means you're still alive. It means you're still breathing. And if you're still breathing,
I don't want to get hit with a copyright, so I'm fast forwarding the
what the heck
music. Sorry, guys.
What the heck? What the heck, folks? All right. So that's how you get in touch with Lane. So there's the information there. Let me put the this in here. So in the description for this video, guys, there's all kinds of contact information. Please be respectful, but please, they think that everything's just going to stop because Lane's in jail. So, we need to make it abundantly clear that things are the overwhelming, the Shannon Walker videos are about to be overwhelming, because we're gonna dissect, in case we haven't done it enough. We're gonna dissect every single lie that she's told, because that's essentially what all this is about, right? It's about her perjury and her husband and his he's just a dirty prosecutor, right? And they think that people are just gonna lie down, and you know what? Maybe most people would. Maybe most people would lie down. But not Lane Jeffrey Meyers. He's not going to lie down. So let's get into this anti-slap. Please, if you care about Lane, send emails, make phone calls, be respectful. What is being done, everyone? If you don't recognize, or you are in favor of what is being done to Lane, I think you're sick. First of all, let's start there. Wanting another person in a cage, for what? For what? I'm not entirely sure for what. For some videos, for a U-turn where you yelled out the window, "Shannon, where are you?" You went to city council and booed. You went to O'Reilly's and you just tried to get some exhaust bolts for your car. But the employee behind the counter wanted to be a passive aggressive prick. And that's on you. You know, that's your fault. That was the coolest I think I'd ever seen Lane. You know what I mean? The coolest I'd ever seen Lane is when he was talking to Jordy. So, you know, so you want him in a cage, right? And you say, oh, well, he had it coming to him. He, you know, maybe I'll just get into this anti-slap motion instead. It's probably a better idea. How's the chat doing? Chat doing good? Welcome in, everyone. Dolores, Tag, Sassy, NWC. I think I saw a couple mods. It's going to be a long day, mods. I don't expect that you're going to be able to hang in there for the long haul, but I do appreciate whatever service you have. What's 762 saying for one voicemail and for one? So yeah, that was the original injunction was over one voicemail. I'm not sure if it was how many emails it was. I'm not sure. I don't remember. But we can, after this anti-slap's over, how about we'll go through the court audio. That's right, Liberty Troll. He's sitting in a jail cell. So, you know, for you, I would. Where the hell were you? Where was that? I don't know where it was. It wasn't close though. But we gotta stand up, guys. There has to be a point where we say, okay, enough's enough. And I might not like Lane. I might not like the way he behaves or speaks or whatever. But you want him to be in a jail cell. That's what you want. You want him in a jail cell for speech. You know what that means, then, right? Yeah. I mean, hopefully you're not so dumb that you don't recognize what that means. It means that whatever he said, they will lock you up too.
That's right. I really like this guy. I've never met him. I don't have any skin in the game with him, but this is a public service. And what he's saying is this is going to create a precedent that if you say anything bad about the government, this is what was going on under the Biden administration. And this is what is still going on in Europe. Okay. So we know that the far left and people like Obama have been pushing hard for this forced speech, like you have to call people by their pronouns, like, you know, you have to call a man a woman, otherwise you might hurt their feelings. And this goes back to the German crime of insult, where if you say something negative about someone, it's a criminal offense. And so it's the Europeanization of America. It's precisely what our founding fathers fought against. We didn't want to have that. We wanted to be able to speak our minds and be able to speak freely. And so that's why I'm really watching this case closely, because I'm very, very concerned. This will create a precedent. And what really alarms me the most is the Californiaization of Arizona, where you had all these basically far left Marxist voters who voted for the destruction of California and high taxes. They couldn't handle what they voted for, and they've been moving to states like Colorado and Arizona, and they're voting the same exact way. And we see the Californiaization of the judiciary, of the Arizona judiciary and prosecutors. And it's just blowing my mind. It's almost like the board where it's being replicated now in Arizona, an open carry state. And I just am terrified what's going to happen to people who believe in the right of self-defense and open carry and all that. So I'm really, really watching Arizona. And this is another reason why I'm trying to get barred into Arizona, so I can help people like Lane. Love him or hate him, Lane Meyers is on the precipice. He's at the lead. And what happens to him is going to set a precedent for everything else that comes after him. So Another reason why I support recall elections, because the only chance you have when the appellate court fails, right, is recalling these public officials who put down, who make these absurd rulings and decisions that ultimately erode your rights. So I really like this guy a lot, and I hope that you'll keep following his channel. The name of his channel is "This Is a Public Service," and I really dig it. I can tell this guy is, he's a spiritual dude. I can tell that he's kind of filled with the Holy Spirit. He's a good guy, and I want you to check out his channel. All right, here we go.
It doesn't even need to be as bad. They will lock you up too. There's no conscience on these people. They went home and there's no conscience on these people. It's completely and utterly disgusting. Pima County Superior Court. The State of Arizona versus Lane Jeffrey Meyers. Motion to dismiss pursuant to ARS 12-751. Defendant Meyers moves this court to dismiss this action pursuant to Arizona's anti-SLAPP law ARS 12-751 for the reasons set forth herein. SLAPP stands for Strategic Action Against Public Participation, ARS 12-751. Introduction. The ARS 12-751 defines legal action for the purposes of this statute as including any criminal prosecution except for drug trafficking offense, including in Title 13, Chapter 34 or 34.1, a riot or serious offense or violence or aggravated felony as defined in Section 13-706 ARS 12-751 J1A 2. Is that how that's, or is it II? I don't know. The charges Mr. Meyers is facing do not fall into any of the exemptions to the statute's application. Therefore, the anti-SLAPP law clearly applies to this case. As recently as February 2025, Maricopa County Superior Court Judge Sam Meyers applied Arizona's anti-SLAPP law to criminal prosecution involving fake electors. Arizona's anti-SLAPP law was amended in 2022 to explicitly apply to criminal prosecutions. A plain reading of the statutes on its face, as well as the unique facts and circumstances of this prosecution, indicate that this matter is precisely what the legislature likely envisioned when enacting the anti-SLAPP law. Most prosecutions for violations of injunctions against harassment involve family law disputes. This case is different. Factual history. And guys, if you don't want to listen to me, in the description, there's a link to the anti-SLAPP motion. It's there for you. That way you can read it yourself. You don't have to hear me read it. Share it far and wide. Share it with anybody in the news. Share it with everybody. Share it with your grandma. Share it with your kids. Share it with everybody. Everybody needs to see this. This is what courage looks like. Okay? This is what a patriot looks like. Open your eyes, guys. Share it. Mr. Meyers is an investigative journalist for Freedom Productions, LLC, who covers local stories related to public employees in Pima County. For the past 9 months, Freedom Productions has been investigating and covering apparent corruption at Tucson City Court, Pima County Justice Court, Pima County Superior Court, and at the City of Tucson Prosecutor and the Pima County Attorney. Mr. Meyers' reporting has also focused on the relationship between the University of Arizona Law School and local courts and prosecutor offices. While being unlawfully charged for booing at a Tucson City Court meeting, Mr. Meyers began investigating the City of Tucson prosecutor Matt Walker. Mr. Meyers quickly discovered that Matt Walker has a video on the AAPAC website where he tells prosecutors how to weaponize disclosure and railroad innocent defendants. Mr. Meyers made a news video showing that website. On that website, which is public information. Matt Walker lists his biography, including his wife, Shannon Walker. From a Google search, Mr. Meyers learned that Walker was, at the time, the director of special projects at the University of Arizona Law School. State actor. State actor. Ms. Walker is a state employee employed by the state of Arizona, a state actor. Mr. Meyers called Mrs. Walker on her publicly listed phone number and left a voicemail asking if she could help him with a special project as a pro se litigant in Tucson court. Mr. Meyers left a single voicemail on Ms. Walker's work phone, which is listed on the university website, which encourages people to call if they have questions. Mrs. Walker sought an injunction against Mr. Meyers based on this single contact, which served a legitimate purpose, was not an act of harassment, and which was not a series of acts. All right, we're just gonna pause there for 1 second, and we're gonna listen to that. We're gonna listen to that phone call because we got everything. Everything. We have everything, and you're not going to be able to hide it because we have everything. And everybody else has everything too, because it's open source there on YouTube for everyone to go ahead and download, and please share far and wide.
You have reached Shannon Walker, Director of Special Projects at the James E. Rogers College of Law. Please leave a message and I'll call you back as soon as I have a chance. Thanks.
Hi, my name's Lane Meyers, 520-771-2021. I see you're Director of Special Projects. Well, I'd like to ask if you could approve a special project where you help me end your husband's career for being a crooked-ass cop, prosecutor, wannabe, whatever he is, hiding these cops from prosecution. I figured the U of A, maybe Stacy could help me. Maybe I should talk to you or Stacy or maybe one of these. Because, you know, my wife also is an alumni of the College of Law and is actually has taught there. So, like, we got two sides that are about to come crashing together here. So you can help me teach your husband how to follow the law, or I'm going to take his career. So I figured, since I'm a member of the community and my wife's an alumni of the law school, that maybe I could get access to the materials at the law school in order to fight for justice, since Stacy's all about justice. So I guess I got to call Stacy next.
All right. Was that a crime? Did he threaten her? Was that a crime?
Well, so I can kind of see where this is headed. So the statement, I'm going to take his career, that's what the prosecutor is going to hinge on. I don't see that as being a physical threat. And so I'm having a hard time believing that that could uphold anything, because taking someone's career could mean recalling them, as opposed to saying taking someone's life. So I have got a real problem with that being a harassment charge, where it would be amount to a felony. So I like what Concerned Citizen's doing, is that he's sort of breaking down to try to find out, you know, where is the threat? Because it has to be a clear and present threat to do physical harm. That's my understanding in California and Texas. Now, maybe Arizona has a different kind of law, but so far, I really like the way he's leading us down the road to explain the so-called evidence and ask us, like, what's going on? Do you think that could arise to the level of a crime that could incarcerate someone? And I want to know what you guys think.
It's a serious question, right? I mean, that's why we're here, right? That's why that's why this is happening. So was that a crime? He actually talked to Stacey Jane. Welcome in, Michael. No crime. I pinned right there some contact info. Send him an email. I think he's had 24 hours to read. Shoot. He's had 24 hours to read this, so I don't know, man. All right. So Mr. Meyers' investigation into judicial proceedings underlying Ms. Walker's injunction revealed what Mr. Meyers describes as corruption. Getting those spam calls from a area code I want to answer numbers from. All right. Mrs. Walker's injunction reveal what Mr. Meyers describes as corruption. Mr. Meyers' investigation showing that during Mrs. Walker's testimony before Judge Dawn Weiland on October 9th, 2024, Mrs. Walker alleged multiple acts or contacts by Mr. Meyers that did not occur. In other words, Mr. Meyers' investigation showed that Mrs. Walker lied under oath to obtain an injunction against him. Mr. Meyers' investigation showed that Judge Weiland did not probe or question Ms. Walker's testimony. Mrs. Walker and Judge Weiland laughed and joked during the hearing. Judge Weiland declined to order the removal of Mr. Meyers' YouTube videos, but issued an injunction against harassment against Mr. Meyers based on Mrs. Walker's false testimony. Well, guess what, guys? Guess what? Like I said a second ago, we've got everything. Look at this one, just sitting on it. They're just sitting on it. They don't want me to have it. Usually they produce these audios instantly. For some reason they're holding that one back. All right, so what do you say? The 9th. That'll be this one.
Okay, this is case C 2024-6055. The plaintiff is Shannon Walker and the defendant is Lane Meyers.
So I do want to say one additional thing. The Pima County Superior Court, they purposely hid this audio from us for months. Okay? For months. But we knew it existed, right? We knew it existed because we're not dumb. All right? And we can follow things, right? But they tried to say that this was sealed, that this was under a seal, but that's all lies. It's just more lies from the court. But we're supposed to, let's put our faith and our trust. Let's just put our faith and our trust in it, right? Honorable Douglas Metcalf, just let the process play out, right?
Ms. Walker, this is a time and place set to hear an injunction against harassment. Ms. Walker, could you please stand and raise your right hand? My clerk's going to swear you in.
Do you solemnly swear to speak the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
There's the first lie.
So,
can we count the lies, everyone?
Thank you.
Let's count the lies. Let's start with that one.
Harassment.
I swear to speak the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Liar.
So,
how about this? Can somebody in the chat help me out? Can we open up a note or a Word document or something, and let's put, can we record and put timestamps for each lie? Because we're 11 seconds into the hearing, and the first lie has already occurred. Jita, up in the pinned comment is the contact information. I believe that Bad Apple Media, Oakland County, is not a good county. From what I've heard, Arizona is a police state. Yes, it is. I'm sorry, I'm getting off track. I start reading the chat and want to get in there. But anyway, can somebody help me out? Is that Sassy saying they can help me, or somebody? Times the first lie occurs.
And raise your right hand. My clerk's going to swear you in.
Do you solemnly swear to speak the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
She just said yes, that she would not lie. 11/25/27. 11/25/27 is our first lie. Thank you very much.
So, thank you. First off, can you state your first and last name for the record and spell them, please?
Shannon Walker, SHANNON WALKER.
Okay. So, Ms. Walker, I'm going to be asking you some questions about the allegations that you've made in your petition here. Okay. I'm also going to ask you some questions about guns. Now, I don't want you to think that I have some super secret information back here. I have no information at all regarding the defendant or anything. These are statutorily required. And so if I ask you a question, don't think I know something because I don't.
Understood.
I've only got what you've given me here in front of us. So, and I've read through the allegations here and I'm a little confused. What is going on?
So I work at the College of Law. My spouse, who is with me, Matt Walker, is a prosecutor for the city of Tucson. Mr. Meyers is a defendant in a case that my spouse is prosecuting. For some reason, Mr. Meyers has chosen to start harassing me because he discovered that we are married.
All right, well, let's dissect that. Let's dissect that and get the exact timestamp, because that sounded like a lie to me.
For some reason, Mr. Meyers has chosen to start.
So is it right there? I mean, is it right? Seriously, is it right there?
For some reason.
For some reason. So for some reason, 11/26/38. 11/26/38 is the second lie. And why is it a lie?
In a case that my spouse is prosecuting. For some reason,
for some reason, she knows the reason. He left a voicemail that explained the reason. So she could have had her voicemail transcribe it, and she could have handed it over and said the truth, right? She could have said, Mr. Meyers wants to know if you can help with, if she can help with a special project, right? You don't have to lie, right? You don't have to tell a lie, Shannon.
Meyers has chosen to start harassing me.
Chosen to start harassing you. We're going to call that a lie.
For some reason, Mr. Meyers has chosen to start harassing me.
Chosen to start harassing you. 11/26/41. 11/26/41. Chosen to start harassing you. I believe at this point he's sent one voicemail. That's harassing. Okay.
Because he discovered that we are married. It's primarily been through YouTube videos that he.
Is that a lie? Is it a lie to say that you're harassed through YouTube videos? What if you didn't watch it? What if you just didn't watch the...
So one thing that I'd like to touch on as an attorney, in California and Texas, harassment has a distinct definition. And I haven't looked it up for Arizona, but if somebody can and throw it in the comments section, harassment actually has a legal meaning. And it usually means a clear and present intent to cause bodily harm or injury. Now, so when she's saying I'm being harassed, I'm wondering, what does harassment mean in Arizona? Because in order for it to rise to the level of a felony, it's got to be pretty serious. And if there's no clear and present intent to cause, grievous bodily harm, I don't know how it could possibly rise to the level of a felony. I mean, I get it that she's married to a prosecutor, but she also works for the state. Now, me personally, I wouldn't be reaching out to the wife of a prosecutor who's prosecuting a case against me. But I don't know of any law that says that he can't. And so I'm at this point, at the nexus, the genesis of this case, I don't. And I want to know what harassment means. Okay, I'm one of these guys. I don't make judgment calls until I see all the facts and the evidence and the law. So can somebody please tell me what harassment means in the comment section, and I'll put it up on the screen. It's just that I'm responding to emails as I'm listening and talking to you guys, trying to work, and I'm going to be jumping on an airplane pretty soon to head out to Texas for a charity event for the Marine Corps. And I just, I'm trying to juggle a bunch of things and share what I know with you. And I'm hoping you can interact with me and educate my audience too, because I'm learning. I'm not licensed to practice law in Arizona. I'm learning too, I just want to cover the story because I don't think that Lane's getting a fair shake. That's all. There's no lawyers out there online really talking about it, at least not in a positive way or a neutral way. You know what I mean? So that's kind of what I'm doing here. So let's get back into it. Let's get back into the video.
The YouTube video. Would you still be harassed?
It's primarily been through YouTube videos that he makes about me, where he shares my contact information and YouTube videos that he makes about me, where he shares my contact information and encourages his 8,000 plus YouTube channel.
What do you guys think?
That we are married. It's primarily been through YouTube videos that.
Okay, I don't think that you can be harassed. I think that's a lie. I think that is disingenuous to say that I'm being harassed by YouTube videos. What's the YouTube video doing? Is it jumping out of the phone and slapping you in the face? Is that what's going on? Is that what's happening here? 11/26/49. 11/26/49. You can't be harassed by a YouTube video. Okay? Unless the YouTube video is calling for violence.
Okay, so I just see here that Tide Pod Church has said that Arizona harassment is defined under ARS 13-2921. Any conduct directed at a specific person that would cause a reasonable person to feel alarmed, unsafe, annoyed, humiliated, or mentally distressed. I'll tell you right now, that is one of the most vague and ambiguous statutes I've ever heard of. And I would challenge that as constitutionally prohibitory. I think that if this statute was challenged, it would lose because it doesn't really define. I mean, anybody can say, I feel mental distress. That is like what they do in England, right? That's how they get people. That is like a United Kingdom definition of harassment. Okay, that is ridiculous. It's not. I mean, what does annoyed mean? What does humiliated mean? What does mental distress? No, that's crazy. Of course, he's going to be convicted of harassment based upon that because it's purely subjective. So I think you could challenge the statute on its face and you could get that overthrown. I think based upon reading that statute, the only chance that Lane Meyers has at this point is to go all the way up on a certiorari or some kind of habeas corpus type of an issue here. This is alarming to me. This is alarming. This is humiliating to see that a legislature would write such an overly broad, vague, and ambiguous statute that's capable of being determined by someone who's a nitwit, but by someone on the jury who just decides, well, I would feel humiliated if somebody called me at work. No, that is not. No. So typically when you try to get a restraining order against someone, at least in California or Texas, you got to show that you're being threatened with some kind of physical harm. I don't see that here. And based on this statute, I'm scared for Lane that unless he challenges the statute on its face, he's in for a tough road because it is absolutely vague, ambiguous, and unintelligible as to what any of these things could possibly mean. A reasonable person? What's a reasonable person? I mean, somebody who teaches at a law school, a far lefty, right? Who's scared of guns and afraid of free speech, who thinks you should have safe spaces? No, it's open to too broad of interpretation, in my opinion, as a lawyer. If this was a statute that was in a state that I'm licensed to practice law, I would challenge it on its face. And I think that I would have a pretty good chance of winning something like that. What do you guys think? I think it's crazy. I don't like it. I think it's absolutely insane. Anyways, let's get back into the video.
Unless that's happening, I don't. Nobody wanted that up there, but whatever. Where is it though? Ooh, I didn't even send it to myself, did I? Thought I'd be able to find it faster, so oh well. Oh well, we can't segue into that. But anyway, you can't be harassed by a YouTube video. Nobody's calling for violence, right? Nobody's calling for any violence, Shannon. Anybody know where you can find stuff that you've clipped? Probably not.
Either way, I have the right to question you. And you can't weaponize the fake court like you and your husband, or like Stacy and your husband, all that shit. It's not going to work. You're just going to get sued. So, public employee, public scrutiny. Welcome to the real world. It's called. It's when you're an adult, you have to deal with scrutiny. Right to free press. I want to ask you. You can indicate guilt. I'm giving you a chance to say, hey, I know it looks wild what's happening, but that's not true. But instead you want to run and hide. That's fine. You have that right. I'm not going to hurt you. I don't have nothing. But in a working capacity, I am going to, attempt to get a quote from you. And if you don't want to give a quote, then just say you don't want to give a quote. But either way, I have the right to question you. And you can't weaponize the fake court like you and your husband, or like Stacy and your husband, all that shit. It's not.
All right, so she can't be harassed by a YouTube video. Okay, nobody wants to hurt you, Shannon. You clearly want to hurt Lane. It's obvious that you are an evil, evil, evil woman that wants to do harm to Lane. But nobody wants to do harm to you. I don't want to see harm done to you.
He makes about me where he shares my contact information and encourages his 8,000 plus YouTube channel followers to contact me and also harass me. He also has contacted me directly through phone calls. He calls me, I do not answer, but leaves voicemails that are threatening.
Is that true? Is that the truth?
So guys, I have to go make a quick phone call, but I'm going to keep playing the video. Again, I'm getting ready to ship out to Texas, so I'm just trying to get as much in as I can because it's been a pretty rough week for Lane, and he doesn't have anybody out there really that are lawyers talking about it. So I wanted to share with you what I found, and I'll come back and make some comments.
There were a couple there. We're going to have to unpack this one.
Directly and also harass me. He also has contacted me directly through phone calls, contacted me directly through phone call.
Okay. Somebody with more brains than me might be able to help me with this one. Admittedly, I'm an idiot. But maybe somebody else can help me out.
He also has contacted me directly.
If you've contacted someone directly, what does that imply? What does that imply? Sassy, we have to, before we get to the timestamp, we have to make sure, because I think there's more than one lie here. So we have to be precise.
Also harass me. He also has contacted me directly through phone calls. He calls me. I do.
Okay. Contacts me directly. If you have direct contact with someone, that means that you've spoken to them. Direct contact. Direct contact. Direct contact isn't a voicemail. That's not direct. That's you listening to your voicemail. That's not direct. That's indirect, right? So that's a lie. Let's get the timestamp for you.
To me and also harass me. He also has contacted me directly.
Contacted me directly, 11/27/04, 11/27/04, 11/27/04. He has not contacted you directly. He sent you a voicemail. One single voicemail. Remember, this is October 9th. Okay? This is October 9th. This is October 9th.
Through phone calls. He calls me. I do not answer, but leaves voicemails that are
Does he leave voicemails
threatening.
that are threatening? Does he? Chat. Help me out, chat. Does he leave voicemails that are threatening? Bad Apple Media, I think you might be mistaken on this specific case. One thing you'll need to realize is pro se litigant must behave like one of them. He hasn't, so they're forcing him to let the mouthpiece take over for him. He was granted his pro se motion yesterday, and I haven't in front of Metcalf. In front of Metcalf, I have not seen Lane act any type of way that would, in my opinion, right? This whole thing is about my opinion, right? There's some facts. We're talking about the facts. Those are facts, but over the top is my opinion, right? So I'll just politely disagree with you there. All right, let's get the times. That wasn't the timestamp, was it?
Also harass me. He 1,000+ YouTube channel followers to contact me and also harass me. He also has contacted me directly through phone calls. He calls me. I do not answer, but leaves voicemails that are.
Is that 2 lies? Okay, voicemails. We're gonna break it up. Sorry, Shannon. Sorry, no fucking grace for you today, Shannon. You'll get no grace from us. No fucking grace. This is 2 lies. Well, before maybe it would have just been 1 lie. No, bitch. 2 lies. 11/27/11. 11/27/11.
He calls me. I do not answer, but leaves voicemails that.
Voicemails is plural. He's left 1 voicemail. 1 voicemail. Liar. You're a fucking liar. You wonder why people are upset at you, Shannon? We're how far are we in? We're 3 minutes in. Sassy, what are we up to? How many lies? Tell me, how many lies are we up to? Exactly, Lawrence. Exactly. What are we up to? Six lies. (11/27/11). We're 3 minutes into the hearing and we're at 6 lies. Okay, Shannon, cool story.
Yes.
You solemnly swear to speak the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You solemnly swear to speak the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Dirty cunt. Three minutes in, lying her ass off. Okay, Shannon. You've got tons of integrity. Yeah. This is just the first judge.
Leaves voicemails that are threatening.
that are threatening. Lie.
All right, so guys, we're at about. Let me see. What's the timeline on this thing? About 221, 222. Let me write it down. Let's see here, 222, I guess. It's a long video. We're gonna have to finish it up when I get back from Texas, because I gotta get ready to ship out. But listen, obviously I don't condone, calling people names and all that, but I can tell that, look, good citizen, this is a public service. This guy is not happy because he's right. If there's only been one voicemail and you're saying plural, multiple voicemails, that is lying under oath. And I mean, that's punishable. That's an offense. And so give me a bunch of ones if you think the courts or the prosecutor are going to do anything about that perjurious statement. Give me a bunch of twos if you think they're going to ignore it. Give me a bunch of ones if you think they're going to prosecute her for lying under oath. One, lying under oath. I'm sorry. One, if they're going to let her get away with it. Twos, if they're going to prosecute her for lying under oath. Yeah, exactly. So what I'm going to do here is, obviously, I want to thank everybody for joining the show today. And again, this has been a working day for me. So I've been trying to get work done and just kind of like do a show because I haven't been live for so long. And I know I'm getting people calling me and texting me and emailing me saying, when are you going to do another show? Well, so as you know, I blew my back out. So it's been rough, but I'm at a standing desk and I'm doing everything that I can. And I'm just loathing having to get on an airplane because as soon as I sit down, my whole left leg lights on fire. So I'm doing my best to just get through the day here. Good seeing you, Let's OTVO. Good seeing you, Gata. Westman 78. Kevin Birnarski, thank you for joining me, brother. NWC. Gata 1. Let me see. James Forbes, as always, thank you, brother, for always supporting my show. Guys, I really appreciate all the donations, the super chats, and the memberships, gifting memberships to other people. It really means a lot to me. I appreciate you guys who have bought copies of my book about how to become a lawyer with no law degree or undergrad. I'm teaching my daughter how to run a YouTube channel. Give me a bunch of ones for my daughter doing all the shorts the last couple of days. She's been helping me get up all of the YouTube shorts. Make sure to go back and like and subscribe all my shorts as well. The short videos, not my gym shorts. And support the channel as best as you can. Obviously, when you save my videos for later viewing, that gives a real algorithmic boost. Since I haven't been going live as much, obviously, I haven't been getting as much love from the Google gods, the YouTube gods. So any help you guys can do to, just keep my videos running all day so you're watching them and you got, YouTube seeing that you're watching it and listening is going to be really, really helpful. Always let the commercials play because that helps monetize the channel and gets me more views. And ultimately, you want to get these videos out to other people who are on the fence about being patriots, right? There's a lot of people who are just on the fence. They're scared. But once they see that enough other people like you and me are standing for the common man and for our unalienable rights, then they're going to join our side. It takes leaders, right? I'd rather have a lion leading an army of sheep than a sheep leading an army of lions. Okay, so that's, look, we need all the help that we can get. I hope you guys understand where I'm coming from. So thank you again, everybody. Sinful Toaster, thank you so much for coming on in. And what's the matter, you? What's the matter, you? Thanks always again for your views as well, brother. And Pro Se America. Let me see here. United States of America Inc. Thank you for coming and joining the channel today. And everybody, give me a bunch of ones for this is a public service, for doing a really terrific job as a citizen journalist, as well as Reluctant Prophet and all of Lane's people who are out there trying to get the word out and support him. And again, my views don't necessarily reflect the views of my law firm or other lawyers that I work with. This is just what I do as a citizen journalist on my spare time to try and educate people so they can know the law and mean to keep it well and understand natural law and how it diverges from the modern academic interpretation of constitutional democracy, which we are not. We are a constitutional republic governed by natural law. Our laws come from a creator, and that means they cannot be taken away by the state. The Marxist administrative state does not like that. They don't like people like me. And that's why I need your support so we can form parallel systems outside of the system that they created after they tried to destroy our republic and try to return us back to the law of natural law and natural rights and individual liberties and freedom, where we homeschool our kids, we homestead, we grow our own food, we collect our own rainwater, we understand the concept of natural immunity and allow our bodies to heal themselves the old way for thousands of years that was done, without being reliant upon pills and drugs and things where the big pharma makes billions of dollars. And they're the ones who control all the news media. They're the ones that control all the commercials, brainwashing your children and brainwashing you into thinking you need something that we never did. So again, thank you for joining me. God bless all of you. Make sure to like and subscribe. Make sure to save, because we never know when the thought police are going to take down this channel. Semper Fi, do or die.